Good morning, everyone, and thank you. Good morning, everyone, and welcome. My name is Rebecca Tepper. I'm the Secretary of the Executive Office of Energy and Environmental Affairs and the Chair of the Energy Facilities Siting Board. This is a hybrid meeting of the Energy Facilities Siting Board taking place at the offices at the Department of Public Utilities, 1 South Station, Boston, and on Zoom. This hybrid meeting is intended to allow everyone to see and hear all speakers here and on Zoom. This meeting is being recorded and will be available on the Siting Board's YouTube channel. For remote attendees, if you are having any difficulties with Zoom, please call or text 857-200-0065 for assistance. With me today are the other members of the Siting Board. Jeremy McDermott, Chair of the Department of Public Utilities. Elizabeth Mahoney, Commissioner of the Department of Energy Resources. Bonnie Heipel, Commissioner of the Department of Environmental Protection. Tom O'Shea, Commissioner of the Department of Fish and Game. Doug Goutreau, Director of Permit Regulatory Office and designee for Secretary Eric Paley of the Executive Office of Economic Development. And remote, we have Chris Callahan, Policy and Regulatory Affairs Manager, serving as the designee for Dr. Robert Goldstein, Commissioner of the Massachusetts Department of Public Health. Michael Cahill, the Mayor of the City of Beverly, who is our public member, and Joe Bonifiglio, who is also a public member. Also here on the bench with us is Andy Green, Director of the Siting Board, who will be serving as the Zoom meeting host. I would like to give a special welcome to Mayor Cahill, who this is his first meeting of being with us at the Siting Board. Welcome, Mayor. Thank you for your time and effort in getting ready for this meeting and for being on this board. So we have one item on the agenda today, which is consideration of the tentative decision in EFSB 2507 regarding individual and comprehensive zoning exemptions requested by, is it Morgora? How do you pronounce the name? Moraga Storage LLC for its proposed 180 megawatt, 720 megawatt hour energy storage system in the town of Oakham, Massachusetts. The project includes a new air insulated substation, a new switching station, and a new 125-foot overhead tap line connecting to National Grid's A127-4 115 kV transmission line. The Siting Board provided notice of this meeting today to the service list for this proceeding and posted it on the Siting Board website. The Siting Board also provided notice of this board meeting under the Massachusetts Open Meeting Law. The Siting Board distributed the tentative decision on June 15th and invited comments by Tuesday, June 23rd. Comments were provided to the board members and made publicly available through the Siting Board's online filing room. The sequence of today's meeting is as follows. First, the Siting Board presiding officer will present the tentative decision, followed by presentations from the company, the town of Oakham, and other interveners, limited participants, and then public officials. Finally, as time permits, we'll listen to comments from the public. The board will then begin deliberations on the tentative decision, consider possible amendments to the tentative decision, and finally, to vote on the tentative decision. The record in this case includes many written documents produced during discovery, transcripts, and briefs. We also have many written comments that were presented during the proceeding, and over the last few days, we have received additional written comments, which have been provided to the board members. So when thinking about what you'd like to share here live today, you can be assured that your written comments have been very helpful in understanding your concerns and suggestions. We do want to make sure that there's adequate time for us to hear from all parties and public officials today. Thus, as a presiding officer outlined on Tuesday, we are going to have some time limits on presentations and comments. So it's going to be 10 minutes for each presentation by the staff, the company, and each set of interveners, 4 minutes for limited participants and public officials, and 3 minutes for public commenters as the time permits. We will remind speakers when it's time to finish at the 1 minute mark, and then at the time. A stenographer is here today to transcribe everything said to make an official record of the meeting. Everyone should speak slowly and clearly and allow the prior speaker to finish before you begin to speak. This will ensure an accurate transcript. So we understand that there are many people attending this meeting here and on Zoom, and many people want to convey their sentiments to the board. We want to hear from you, and we request that everyone be respectful and not disrupt the people who are speaking, so we can hear from everyone and everyone has an opportunity to respect each other and listen to each other's comments. So I'm going to start by asking for council to enter their appearance, starting with Mr. Green.
Secretary, members of the board, my name is Andrew Kaplan at Pierce Atwood LLP, representing the company.
Good morning, members of the board. I'm George Fucci, and I represent the town of Oakham. Good morning, Kenneth Weiss, representing Representative Horner.
And I'm Stephen Ferry, and Mr. Weiss asked me to assist.
Thank you. That's it, right? Okay. All right, so then we are going to start with presentation by the presiding officer. Good morning.
Board, my name is Daniel Kelleher, presiding officer in this matter. I'm here to present the staff's tentative decision regarding Maria Storage LLC's petition to the siding board regarding the battery energy storage system, also known as a BESS, that it is proposed. Presiding officer, could you raise the microphone a bit so we can hear better here? And for the battery energy storage system that is proposed for Oakham, Massachusetts. With me today are members of the siding board staff who have worked with me in preparing the tentative decision. We have Andrew Green, the director of the siding board. We have Joan Foster Evans, the general counsel of the siding board. We have Wayne Wong, the assistant director of the siding division, and we have Claire Lowe and Caleb Chang, both analysts with the siding division. I plan to summarize the history of this project, to identify significant issues related to the project, and to recommend to the board options for addressing those issues. My colleagues and I are available throughout this meeting for questions. The short history of the project is that the company pursued its BESS project beginning in about November of 2022, several months after the town of Oakham had passed an amendment to its zoning bylaws that would, as all parties who have rendered an opinion on this agree, would prohibit the project that has been proposed. I will refer to the town of Oakham as the town and to provisions of the town's zoning bylaw that refers to BESS as the town's BESS bylaw. The company has sought exemptions from the town's zoning bylaws because the bylaws would prohibit construction and operation of the project. The central question the siding board must decide in determining whether to grant the requested zoning exemptions is whether the project is reasonably necessary for the public welfare and convenience. And I would like to focus on that determination in my presentation. Be sure the interveners have raised other issues as well, including the company's conduct in pursuing the project. I have to re-roll the tape. Okay, start over in an abbreviated fashion.
We do want to make sure everybody has an opportunity to hear your comments, so I suggest that you do start over. I'm sorry.
Sure, no problem. Good morning. My name is Daniel Kelleher. I'm the presiding officer in this matter. I'm here to present the staff's tentative decision regarding Morega Storage LLC's petition to the siting board regarding the battery energy storage system known as a BESS that it has proposed for Oakham, Massachusetts. With me here today are various people from the staff who have assisted in drafting the tentative decision. They include Andrew Green, the director of the siting board, Joan Foster Evans, general counsel of the siting board, Wayne Wong, assistant director of the siting division, analysts Claire Lowe and Caleb Chang. I plan to summarize the history of this project, to identify significant issues related to the project, and to recommend to the board options for addressing those issues. My colleagues and I will be present for this meeting to answer any questions the board may have. The short history of the project is that the company pursued its BESS project beginning in November 2022, several months after the town of Oakham had passed an amendment to its zoning bylaws that would, as all parties who have issued an opinion on this issue agree, prohibit the BESS project the company has proposed. I will refer to the town of Oakham as the town and to the provisions of the town's zoning bylaw that pertain to BESS as the town's BESS bylaw. The company has sought exemptions from the town's zoning bylaws because the bylaws would prohibit construction and operation of the project. The central question the siting board must decide in determining whether to grant the exemptions is whether the project is reasonably necessary for the public welfare and convenience. And I would like to focus on that determination in my presentation. The interveners have raised other issues as well, including the company's conduct in pursuing the project, whether this adjudicatory proceeding has been fair, and the uniqueness of the town's BESS zoning bylaw. But I want to focus on the project's merit because the project's merit, or lack thereof, is the primary reason people have chosen to be involved with the project, either in promoting it or in opposing it. And issues relating to merit are the issues that most require the siting board's time and attention. I would like to focus my comments on three areas. First is the public need and benefit of the project. Second is the company's site selection process. And third are concerns about direct impacts from the project on residents, the environment, and the town of Oakham. Such direct impacts potentially include noise, damage to roadways, contamination of groundwater, loss of wildlife, and destruction of trees. The tentative decision highlights many benefits of the project. A foundational benefit is the project's contribution towards fulfilling the state's goals of securing 5,000 megawatts of energy storage by 2030 and an additional 5,000 megawatts of energy storage by 2035. Both energy storage goals support the state's long-term commitment to net zero greenhouse gas emissions by 2050. As of December of 2025, the state had met approximately 1,260 megawatts of its 5,000 megawatt goal for 2030. Thus, the state still needed, as of December, another 3,700 megawatts of battery storage to meet its 2030 goal. The project would clearly contribute towards meeting the state-established 5,000 megawatt goal and is therefore a benefit to the Commonwealth. In addition, the tentative decision finds that the project would contribute to grid reliability by participation in the ISO New England wholesale markets. The second issue I will address is site selection. The represented intervener parties, or RPIs, assert the company had an obligation to choose the best available site that it failed to consider many other possible sites in Massachusetts, and that it therefore did not demonstrate that it chose the best possible site. However, under the relevant legal standard, the company is not obligated to choose the best possible site. It is required to consider alternatives to allow the siting board to determine whether the chosen site is reasonably necessary for the public welfare and convenience. In this case, the company identified and evaluated 4 candidate sites, including the proposed site. The comparison among these 4 sites reveals that the proposed site is clearly superior to the other 3 sites, and that the proposed site has important attributes. These attributes include, 1, that the site is immediately adjacent to a transmission line that reduces the infrastructure costs. Number 2, the site is a former auto salvage yard. It's a degraded property. Number 3, the site is relatively secluded, not immediately adjacent to residential properties. And that is useful. The seclusion is useful for reducing noise impacts and also useful for reducing visual impacts. Potential disadvantages of the property include that it is hydraulically connected to headwaters for the Quabbin and Wachusett reservoirs, which are, of course, part of the major drinking supply for the greater Boston area. And another potential disadvantage is that it is in a relatively quiet area, a rural area, in which noise is more noticeable, or additional noise is more noticeable. The tentative decision keeps these potential disadvantages of the proposed site in mind when considering potential impacts of the project. Rather than viewing the disadvantages as disqualifying, the tentative decision assesses the potential impacts of the project and compares those impacts to the benefits of the project to determine whether the project overall is reasonably necessary for the public convenience and welfare. The individual interveners represented by Common Counsel assert the company can instead develop its best project in Tingsboro, but another team from the company is already developing a best project in Tingsboro. The fact that the company is developing another best project in Tingsboro does not preclude the development of an additional project in Oakham. The final issues I will address are the direct impacts, and this is really a set of issues, but direct impacts of the project. The company's plans to mitigate those impacts and the likely extent of some such impacts after the company has performed the mitigation to which it has committed. The parties identify several potential impacts from the project. One of them is traffic, that the traffic, especially from the construction of the project, will damage the roadways. In this regard, the town is planning, it has plans to repair some of the roads, and the board recommends in the tentative decision, the company coordinate with the town to coordinate on repaving. The tentative decision includes a provision requiring the company to compensate the town for damage it causes to the roadways, or that it may cause to the roadways. The tentative decision also makes sure the town's roads are in the same or better condition than they are now without undue expense to the town. That's the objective of the tentative decision. Another potential impact is noise. Based on Mass DEP, the Department of Environmental Protection policy, their noise policy, board staff looked at whether there was an excessive increase in operational noise levels above ambient noise levels. So there will definitely be elevated noise during construction. We concentrated on what is the long-term noise situation. The company presented very conservative assumptions as it evaluated what would the impact of the noise be. The company also asserted that has been a trend of improving technology where over time the noise levels of technology decreases, and it's expected that over time the noise would probably decrease from the assumptions that the company used in its modeling. Because of the rural atmosphere, the number of residents, though some will be affected, the number is small. Board requirement that the company conduct a sound test after a project is operational. So that's another requirement of the tentative decision. Another impact is wildlife. Again, the noise during construction is expected to be high. It's expected that wildlife will move away during construction. For the most part, however, it's expected that wildlife will return. Abundant other habitat exists in the town, so the disturbance to wildlife will not be widespread. Finally, the lands immediately surrounding the project are not known to host species requiring special protection. Another potential effect has to do with groundwater, and that's certainly a concern of the residents of Oakham. Parties asserted that groundwater could be affected by the project if the project were to catch fire and personnel attempted to extinguish the fire with water, thus driving contaminants towards the ground. But the evidence presented during the hearing, the evidentiary hearing, established that BESS modules have greatly increased in safety in the past several years. In the remote possibility of an emergency event such as a fire, the resulting measurable contamination from the fire to groundwater or otherwise is expected to be negligible because the Oakham Fire Department has been notified that it should not spray water on the fire. And the department is well aware of that practice. Debris removal. So that's another issue. There's debris on the property largely related to the former auto salvage yard. Any debris removal regarding wetland areas will be performed only with the permission of the Oakham Conservation Commission. The board requires the company to remove all large debris on the project site to improve the site. If the Oakham Conservation Commission has concerns that the debris removal will cause unintended consequences, it may prohibit such debris removal. Last night, Siting Board staff issued an amendment sheet. The amendment sheet had proposed amendments that were proposed by the Siting Board staff based on comments that we had received. These proposed amendments, as is customary, the amendment sheet does not include typographical corrections. In a note at the bottom of the document, it says that that changes that are so in a number of cases there are changes to conditions. Those changes are intended to be reflected also in the body of the decision, even though they're not right now contained in the amendment sheet. So to the extent that the board ends up voting and approves conditions, Siting Board staff will understand that the approval includes both the amendments in the amendment sheet as well as the corresponding amendment that needs to be made. In closing, the proposed project is needed under state policy to advance the state's policy for greater energy storage to support the state's transition to net zero greenhouse gas emissions, and it also provides reliability benefits. The project does so in an environmentally responsible manner that keeps effects on the town of Oakham modest. Siting Board staff recommends the tentative decision as amended, and I invite any questions the board may have.
Questions for the Siting Board staff? I imagine most of the questions are going to be for the attorneys. I would like to a clarification on where the houses, the closest houses are and how far away from the site they are.
Well, I mean, there are properties that abut the site.
Okay.
The site is 42.9 acres. I believe the closest houses are over 1,000 feet. Could you speak to that?
Yes, that's correct. The closest residences are over 1,000 feet from the BESS facility.
From the
The
lot
electrical
line
equipment.
or from the equipment?
The equipment.
And can you tell me what does the land look like in between the period in the, I think I know, but, from the project where the equipment is to the houses, what's in between?
Yes. There's also a photo simulation in the TD that kind of gives an idea of what the intervening land
Yeah, I
is.
saw that. Yeah.
So the site used to be an auto junkyard facility. And so it was previously cleared where the cars would park. And in the intervening years, there's been regrowth. So it's partly forested, especially closer to the roadway in the surface protection water area. And then parts of it are newer regrowth or absent of vegetation where the cars used to be.
Thank you.
And it's also worth pointing out that the property has an address of Cold Brook Road. The property dips down to where the actual project is being developed. So that dipping down ends up acting as a buffer against noise transmission
I see.
on that side. And then on the other side is where they're planning to build a noise wall because there's not that same type of natural buffer.
Thank you. Okay, we will move on. Thank you. So we're now going to hear from Mr. Kaplan.
Good morning, Madam Secretary, Mr. Chairman, commissioners, and honorable members of the Siting Board. I appreciate the opportunity to present to you this morning in support of the tentative decision that was issued 10 days ago by the EFSB staff. As you know, this is an extensive and some may say exhaustive process that in this docket took 7 days of evidentiary hearings, more time than with a targeted rate case at the DPU, approximately 400 discovery requests, numerous motions, testimony and cross-examination by the staff, each party of six. Sorry, let me just. Each party cross-examined 6 company witnesses, 8 town witnesses, 1 witness from the represented parties' interveners, initial briefs filed by every party and some limited participants, and reply briefs filed by many of the same. So despite claims that will be made today that this process was rushed, I would note that the record demonstrates otherwise. In the interest of time, my comments this morning will address only certain aspects of the town's response to the tentative decision, which are the only comments received that address specific portions of the tentative decision. In response to the town's comments on the tentative decision, the town claims in paragraph 1 that it reserves its right to appeal the board's decision to the SJC because it disagrees with staff's legal reasoning or findings on approximately 5 out of the 147 pages. The first issue that concerns the town is documented on page 26 to 27, which is a discussion of 2 claims made by the town in their initial brief. Storage is unrelated to renewable energy, and the project is financially disadvantageous to the Commonwealth and its ratepayers. In the tentative decision at page 27, the staff notes that the town did not provide any evidence for its claims and that the project would be unrelated to and would not support renewable energy, nor did it provide evidence to its claims regarding financing or ratepayers' impacts. In paragraph 7 of the comments, the town states this is the company's burden, not the town's burden. However, the town chose not to mention that the staff concluded that sentence with a quote, and the record disproves such statements, unquote, and explains why it made its findings that storage is related to renewable energy and why the project costs would not be borne by the Commonwealth or its ratepayers. The findings by the staff on these pages of the decision are legally sound and supported by EFSB precedent. They are not arbitrary and capricious. The remaining 4 pages that the town believes draws illegal conclusions and/or rulings is on page 131 to 135. That is the analysis and findings section where the staff explains why it is granting the comprehensive zone exemption, including findings made about community outreach. Again, the tentative decision is based on sound legal reasoning, supported by extensive record evidence and EFSB precedent, far from arbitrary and capricious. The remainder of the town's comments are, from the company's perspective, simply noise because they're not based on any fact or law. For example, the company requested meetings with the town officials to discuss a payment in lieu of taxes agreement. The town refused to engage in those discussions, but instead wanted the company's detailed financial documents to be provided in the public docket. Negotiations for a pilot program are only appropriately discussed in executive session, and the town knows that. The town's refusal to be cooperative and instead focus solely on denying the project, delaying the project, or having onerous conditions imposed on the project by either the Conservation Commission or now the Board of Health is one of the reasons why the company would like to see conditions on the EFSB order include language that the town's commissions on boards act in good faith and impose reasonable requirements. There is significant distrust of the company by the town. It is not warranted, as the tentative decision notes, based on the evidence before the board, but it exists. And it is clear from the town's witnesses and the comments in the tentative decision that delay until the project is no longer viable still remains their goal. Another example, the Conservation Commission issued an enforcement order against the company. The enforcement order is focused on auto debris and related solid waste on the property as a result of the former auto salvage operations. It purports to bar any activity of any kind on the property until the company undertake a number of actions, including hiring an LSP, obtaining the town's approval of the LSP, performing statewide characterization, submitting and performing a remediation plan for the entire site, among other things. The enforcement order also demands a redelineation of wetlands at the property, even though the commission has been informed by Mass DEP that a valid order of resource area delineation, which was issued by the Conservation Commission, exists at the property and has not yet expired. There are several legal issues with the enforcement order. It names the company as a violator, even though the company has done no work at the site and has no real property interest at the site other than an option with the current landowner that has not yet been exercised. And the enforcement order is also arbitrary and capricious. It exceeds the commission's authority as it applies to the entire property, regardless of the locations of jurisdictional wetlands resource area. It also apparently sought to preempt the EFSB's review of these issues in its ongoing proceeding, since the tentative decision had not yet been issued and the time of the enforcement order was set. The only way to appeal the enforcement order is by filing an appeal to the Superior Court within a strict 60-day timeline to the file that cannot be extended. The town did not act within the 60-day timeline, and that is why the company had to file the suit in Superior Court, and the town knows that. Morega is hopeful now that the EFSB has imposed a condition regarding addressing pre-existing site conditions. The unlawful enforcement order is no longer necessary and can be rescinded. The company will renew its request to confer with the town again following the EFSB's determination on the tentative decision. The condition that the EFSB proposed in Condition X is much more appropriately suited to addressing pre-existing site conditions at the correct time. After Morega will have exercised its option, will own the property and be responsible for it, and will have proceeded with construction activities and project operations. The company can address site conditions as needed while it is mobilized during construction and other development activities. The enforcement order, on the other hand, supports mobilization twice, exacerbating construction and related impacts and endlessly increasing costs. I'll just briefly respond to two comments in paragraphs 12 and 13 of the company's comments regarding notice of intent. Morega's notice of intent addresses portion of the project that are within the commission's jurisdiction. Because Morega has designed the project to avoid wetland resources and their buffer zones, the notice of intent is necessarily limited to the area of the driveway, which is the only area that enters upon resource area buffer zone. The limited jurisdictional area does not pose concerns related to wildlife habitat, so the company did not need to further evaluate wildlife habitat impacts. Importantly, the notice of intent is consistent with the order of resource area delineation that the commission previously issued to the company, delineating jurisdictional resources areas at the property. It also avoids impacts to subsequently certified vernal pools at the property and their respective buffer zones. The order was issued by the commission after a full walkthrough by the commission of the site. By its own terms, it is binding on all decisions of the commission. Mass DEP has already had to remind the commission that the ORAD remains valid. So in summary, the company is hoping for reasonable communications with the town so that the project can proceed in a safe, timely, and cost-effective manner. Thank you.
Thank you, Mr. Kaplan. We will move to questions from the board. This is not a shy group. Who wants to start?
I will. Can you describe the emergency response plans and how the company expects to respond to potential events?
Yes. So, and I have also brought with me the company's CEO, the company's project developer, so Gus Aditi, Brian Benito, and Sean Morris, who's from ESRG. He's a safety consultant. Also on Zoom is Mark Bergeron, who has information about environmental and wetlands. The emergency response plan is designed in accordance with NFPA 855, and that is a national standard on how responses to fires or any incidents really on the site would take place. It is done in collaboration with the fire department, the local fire department. So, and whatever is needed by the local fire department is usually included within those, within the emergency response plan. So it includes things like how will people be notified, who they're going to notify, and you know, how will the fire department be notified, and what kind of systems are going to be in place for that.
And are there strict time limits on the time by which the company representative needs to notify the authorities?
There are. I mean, in terms of the authorities being the fire department, that happens automatically with an alarm system that goes off, and then there's usually a phone call separate from that, from the site administrator.
Expressing the conditions in the tentative decision.
Or just saying that we have a trouble alarm, and here's what we think it is. The fire department then gets there and evaluates the issue.
Thank you.
Hello.
Hi.
I'd like to hear a little bit more about the current site conditions based on the historical uses. First of all, how the company evaluated those site conditions, solid waste, debris, what have you. And secondly, what the company plans to do to address those site conditions.
So that has been an extensive evaluation. There is, as a result of, although the cars have been removed, there were about 3,000 cars on the site. Although they have been removed, there's tires, there's broken glass, there's pieces of cars, and they were just left on the site. The company will be removing all of that. And I believe that's also in condition X.
I appreciate that it's documented extensively in the record, but did want to hear a bit more about, I know there were suggestions at various points in, leading up to this hearing that work would be done only within the project footprint area. My understanding is now the company plans to address solid waste or contamination issues on the entire site. Is that the case?
That is the case.
Okay. Is your LSP here or available?
They are not.
Okay. Is there someone here who can speak to the findings of their phase 1 assessment?
I believe we have Mark Bergeron on Zoom.
We'll move him to the panel.
Mr. Bergeron, can you hear us?
Yes, good morning.
Great, thank you. SWCA was acting as a subcontractor to Epsilon. Is that the arrangement?
No, SWCA is not a subcontractor.
Okay.
GEI was a subcontractor to Epsilon Associates with regards to any due diligence around oil and hazardous materials on the site. SWCA was hired and had previously done a phase one site investigation for the former landowner prior to our involvement with the project.
Okay, so presumably the company reviewed that phase one as part of its acquisition of the site. Is that correct? I'm looking to the company now.
That's correct.
Thank you. Appreciate it. I don't know, Mr. Bergeron, if it's you or if it's company representatives who can speak just to, the conclusions of the phase one, which were frankly a bit surprising that, not a drop of oil, not a drop of anything on the site after 50 plus years of use as an auto junkyard. If we could hear more about that and hear more about the company's plans, if there is oil or other hazardous material, identified on the site as part of your construction or operations, what you plan to do to address it.
Thank you for that question. Brian Benito with the project company. So the LSP that reviewed the project from SWCA did not identify any wrecks within the property. They did identify some abandoned storage tanks, 55-gallon drums within the actual footprint of the old garage area where presumably the cars were reviewed. That being said, we recognize that through this process and through our own internal process that the site needs to have a more extensive review. We have an LSP on retainer to go about implementing that review, but however, we have not been able to execute upon that due to the enforcement order and waiting for this proceeding to play out to ensure that we are able to meet all the conditions associated with the project approval. That being said, if there are any wrecks found or any MCP triggers within the site, we will, of course, then go through the process that's appropriate and to remediate all of those or any of those findings. But as you do note, the current LSP SWCA report did not find any wrecks. There were some samples of groundwater, 12 samples of groundwater, and some soil samples that were also collected in that limited phase one site assessment.
Thank you. That's helpful. Will that further review take the form of a phase two assessment, or is there a different plan?
Yes, ma'am. That is the plan, is to commission a phase two assessment.
Okay. It is also, I will say, good to hear the company acknowledge on the record just the fact of the law that even if, none of this was your fault, the previous use of the site or contamination of the site, if there is any, that it is now your problem once you acquire it. So under the MCP, you would be responsible for any cleanup in violation.
Yes, ma'am. We understand that.
Okay. Thank you.
Madam Chair. So I noticed in the town's submitted comments, they said the company proposed to conduct appropriate wildlife habitat evaluation and submit the findings with the notice of intent for order of conditions to the Oakham Conservation Commission. Town claims that no such filing was made. Can you speak to that?
Mr. Bergeron can speak with that.
Yes. During the testimony, the question was posed, do we require to complete a wildlife habitat evaluation? And a project is required to complete a wildlife habitat evaluation as per the regulations if there are certain threshold impacts within different wetland resource areas. The project is not proposing any activity, including what the notice of intent activities of the access road within a wetland resource area. So therefore, we don't require as per the regulations, to complete a wildlife habitat evaluation. We are in the buffer zone only, which is an area subject to jurisdiction, and there are no thresholds associated with the regulations that would require a formal wildlife habitat evaluation.
Okay, thank you.
Thanks. So the company noted, and maybe your expert who's joined you today can help with this. The company notes its commitment to providing best safety training to the Oakham Fire Department. Can you provide details on who would be giving that training, how often, what's your plan, before, during, after?
So we do have Sean Morris from ESRG. He would actually be doing the training, so I'll have him address that.
Good morning. Sean Morris, ESRG Energy Safety Response Group. So to speak to that point, there is a code requirement in NFPA 855 as previously discussed as part of the emergency response plan for both initial training to the fire department as well as reoccurring training. Our company takes safety very seriously. We consider code compliance in that sense to be a minimum acceptable level. We always seek to exceed that. We worked with hundreds of fire departments around the world where we determine what the appropriate level and mechanism of training is. That includes, baseline knowledge from foundational battery safety knowledge, then on to site-specific, speaking to the emergency response plan that we develop in collaboration with the fire department. We don't develop plans that we want to put in binders and put on shelves. We want real actionable things that make fire departments comfortable and safer in operating environments. So we conduct an initial training that includes both cognitive as well as hands-on, scenario-based, and then include that training on a reoccurring basis throughout the life of the project.
Have you conducted any such trainings in Massachusetts for any other towns already?
Yes.
Could you give us a couple examples?
Me personally, or
the company.
I've conducted part of the Cranberry Point Carver. I have a working relationship with them, both initial training and reoccurring. Sterling, Massachusetts recently. A lot of projects are still in development, so they're in that phase where we're working collaboratively with the fire department to determine the training needs and the ERP needs. We don't consider that emergency response plan finalized until site construction is complete and we're kind of in the commissioning phase. So those kind of remain in a draft status till then. Some departments choose to bring us in earlier for the cognitive portions and spread it out. Some want it all at once. We really look forward to working on the department and meeting their needs. We're not part of that.
And do you consult with the Massachusetts Fire Services in developing your plans, so the state office?
Yeah, so our company has relationships with both Division of Fire Services as well as NFPA. A lot of our company leadership are previous NFPA positions, and we still have working relationships to determine best practices. Some of what is guided is in NFPA 855 as well as other NFPA, National Fire Protection Association documents about best practices in terms of response. Again, we don't want boilerplate instructions. So once we're able to collaborate with the fire department and say, okay, let's match this exact site specific, this exact site's technology to the department's resources, capabilities, and preferences. So different departments have slightly different options on how they choose to address alarm notifications, response, protocols, just as examples. So once we get to that collaborative phase is really when we flesh out where the content comes from.
And this question might be for Mr. Kaplan or others on the team. Given the nature of the relationship between the company and the town now, and then moving forward, making sure there is an ERP in place and it's robust. There's obviously at least one condition on that. What's the plan for not just developing the ERP, but the ongoing annual check-ins with the town to make sure that the ERP is robust, is followed, and really takes into account the town, the town's needs and learnings?
In regards to that annual kind of reoccurring training, that is a great point you brought up, is that it's not just a retraining of the document, it's a reevaluation of the document. Is there new information? Are there new practices? Is there new technology where in collaboration with the fire department, we say, hey, we should, modify this, or maybe this, tweak this section. So it is a living document for that purpose. That's required both by code and as best industry practice. So as part of that annual reoccurring training, that training is not a one-way delivery. It's a collaborative review of the document associated with the training. I don't know if that answers the question.
Chief Howe from the town did indicate, and as was in the company's comments, that although at the time we weren't allowed to communicate with the town because they believed that this was an illegal process, once it's complete, they will be cooperative with us. So I'm not anticipating any issues with completing the ERP.
Thank you. Thank you, Mr. Kaplan. Quick question. Does the company intend to collect or document baseline data on area well water, current noise level, or pavement conditions?
I know that the current noise level is documented, and then there will be a post-construction noise study to make sure that the actual operation is within, it's not just algorithms, but the actual operation is within the noise parameters. And your
well water, neighborhood well water within a certain radius?
Yes, I believe that one of the conditions that have been added to the tentative decision is to have the company conduct some well water tests to make sure it's safe drinking water.
And documenting roadway conditions?
Oh, roadway conditions. Yes, same. The roadway conditions are on the record now, and once construction starts, we'll be evaluating that with the town.
Okay. And what did you say about the three LSPs or the ability to?
I don't think I said anything.
Okay,
I should have.
Yeah, you should have. Yeah.
The LSP that's retained by the company now is not part of, I would presume, that would be one of the three. The tentative decision asks us to provide the names of three LSPs that we would be willing to work with to the town and have them select the LSP. So we will do that.
And back on emergency response. So it was 24-hour notification on spills or when there's fire response, correct?
Yes.
And incident reports currently, I'm not incident reports, but check-ins, is it?
The check-ins, I believe, are every 3 months.
Every 3 months.
Just to notify whether or not there were any consumer complaints or any safety issues where the fire department had to be called. But if there's an actual incident, I believe that's a 24-hour reporting requirement.
Thank you.
We should talk a bit more about noise. I know that has been a significant concern for town residents. I know that the company, from the materials has evaluated, done a number of models and has committed to ongoing actions related to noise. Wondering if you can talk a bit more about, or we might need to recall Mr. Bergeron for this, up to you. Talk a bit more about mitigation that is planned, mitigation that was considered but not proposed for whatever reason. Just sort of flesh that out for us. That would be helpful.
Sure, and I can have somebody add to this, but the fan throttle level would be at 40%. So that automatically cuts down on the noise. It will not be operated above that level. There's a 22-foot, 30-foot sound wall to mitigate any of the sound that would emanate from the project. I would also note that as these are the inverters and the batteries that are in place today, as these develop further, we've been finding, and I mean, it's been documented that they're actually more quiet than they were originally thought to be. I believe noise has not been an issue with Cranberry Point or with Medway. And those are the two that have been tested recently.
Thank you. That's a helpful overview. Is there someone who can speak in a bit more detail about the sound wall? Why it's put where it is, only on one side of the project? Why the height? Just sort of the specifics behind that and the anticipated effect. Thank you.
Hi, I'm not the sound expert, but as the person responsible for developing the project, I do have a general knowledge. The sound wall is in the southeast corner of the project, primarily due to topography. There's no natural buffer like there is to the west to kind of buffer the noise to those residents. To the east, directly adjacent to the batteries, is a transmission corridor that we will be tying into. Due to the nature of a transmission corridor, the sound travels down that corridor due to the fact that there's no vegetation or trees to buffer it. And the sound wall is really put into place to help ensure that there's no increase of greater than 10 dB at actually one resident down to the southeast, approximately 1,500 feet away. That neighborhood, and specifically that one residence, is adjacent to that transmission right-of-way. And as such, the sound wall was needed to be built in the southeast corner to ensure that we could comply with the no greater than 10 dB increase at that particular residence. Does that answer your question, ma'am?
It does. Do you have modeling on, pre and post sound wall, what the increase would be at that nearest sensitive receptor without the sound wall and what it would be with the sound wall?
So the desktop study, the algorithms and the modeling took into consideration both with and without a wall. The wall was added to ensure that we could then comply with the Mass DEP noise regulations or guidance. As indicated and as conditioned, there will be a post-construction study conducted at those same locations that were conducted or sampled at pre-construction to ensure that the facility is actually meeting the very conservative assumptions that were put into the model in the development phase.
Is there additional mitigation that could be constructed if the models are wrong, if the increase is more than 10 dB? And to clarify, it is a DEP policy. It is not a regulation. But our goal and our interpretation has always been that projects should be designed to suppress sound to the maximum extent practicable. So it's not just, can you meet 10 or not? It's, is it feasible to suppress sound so it's not creating unnecessary noise pollution?
Yes, ma'am, understood. And, that is the way that the site's been constructed currently. With regard to additional mitigations, we would have to then make a determination as to what we could do if we were, in fact, exceeding those guidance thresholds. As Mr. Kaplan mentioned in his brief remarks, the model was extremely conservative in the way that it was built. It was essentially showing all of the battery blocks running with full fan throttle at essentially 2 a.m. in the morning. So the baseline in this very rural community is quite low, given the fact that it's very rural. So the mitigations that we proposed at this stage do allow us to comply with that policy. If we were to, in the unlikely event that we were to see an exceedance post-construction, we would then, of course, have to ensure that we're bringing the facility into compliance, and that would be met with either additional wall mitigation or some other means to ensure that we're complying.
Okay, so I'm hearing additional wall if needed. Obviously, all of this is if needed, right? If what you're seeing after the fact does not match with what's modeled. Is it possible to throttle down more? It sounded like the 40% is also based on, of course, safety parameters that are paramount to everyone.
Yeah, we haven't looked at lower than 40%. 40% is kind of the benchmark that other developers that have gone through this proceeding have committed to throttling at. It's the percentage that the OEM Tesla, who we're modeling this project off of, that's the threshold that they provided to allow us to meet the policy. That being said, I would have to get back to you if we could go lower than 40%, but I think That 40% is where the OEM and the industry feels comfortable with at this point, given that it's shown to ensure at that throttle level to meet the policy.
Thank you.
So we obviously understand we can't operate if we're too loud. So they will figure out another way to do this or shut down the project, which is not really an option. So
I have two additional questions, Mr. Kaplan. One was on the decommissioning bond in the permit. Is it simply a general commitment, or is there a dollar figure for decommissioning?
I think we want to work that out with the town. Others have had, I mean, there are other decommissioning bonds in place in Massachusetts.
Yes.
Around 50 million. Right? Yeah, I don't know what the number is.
Okay.
But there will be a commitment to that as part of an agreement.
And then the second question is relative to the acres of forested area that will be impacted.
There's approximately 5 acres of second growth, third growth forest that would be impacted to install the batteries.
And is there any plan for compensation or mitigation around that?
Yes, sir. It's recently conditioned. We are committing to ensuring that there's at least 1 acre of forested area within the project site.
Thank you. Outside.
Any questions from online? Okay, I have some questions, Mr. Kaplan. Why not put up the solar? Why not comply with the bylaw?
So we did ask the town if that would change their mind, and they said no.
Well, you wouldn't be here if you put up solar.
Well, we suggested that, or we asked if we did that, would the battery storage facility still comply with their bylaw? And the answer on the record was no.
We can ask the town about that. But is there, I guess my question is this a financial reason? Is it a space reason? You know, why not just do the solar?
Yeah, thank you for that question. The site is extensively, guess you want to say burdened or inhibited with wetland resource areas. So it would be a large undertaking and a lot of wetland fill to place any other infrastructure, frankly, on the site other than what we propose at this time. That also being said, for a 180 megawatt facility, solar associated with that would be larger than what the site could even would be larger than what the site could even handle if it were to be a clean, quote unquote, clean site with no resource areas.
I see. Okay. So on the noise, you know, I know construction noise is temporary, but if you're a person living near the site, you know, it doesn't feel that temporary when it's what, 18 months? I mean, that's a long construction period. Is that right? What it is? Yeah. So what are the mitigation measures that are being taken with respect to noise during construction?
Yes, ma'am. So we've proposed standard noise mitigations for that, mufflers and the like. So really during construction, it would be impractical to kind of lower all of that noise just from a safety perspective. So for example, the trucks that are bringing them there obviously, are going to have some noise associated with the big diesel trucks. You know, we wouldn't be able to really limit that. The backup beepers, those are required for safety purposes. As you can imagine, a construction site's a very active and dynamic place. We need to have these safety features in place to ensure that worker safety's being accounted for. So to ensure safety features are being accounted for, we're not really aware of many other options available to the temporary impacts associated with the construction noise, which would be resulting from the construction equipment and the transportation of the equipment to the site.
What will be the construction hours?
We've proposed the construction hours in line with the local bylaw, 7 a.m. to 5 p.m. Monday to Friday. The bylaw does allow for Saturday work, but we have not requested that at this time, but have reserved the right to if needed.
With respect to the trees, 6 acres, that's what it's gonna be a clear cut of 6 acres?
Approximately 5 acres, ma'am. It was initially 6 acres, but we've adjusted the footprint to accommodate getting the facility out of wetland resource areas and buffer zones. So it's approximately 5 acres at this point.
And there's no opportunity for doing any kind of selective clearing?
No, ma'am. We are only proposing to clear the areas that will actually encompass the batteries themselves and the associated facilities.
And how much forested land is left?
Within the property, there, I would say, is limited forest opportunities left on the side of the facility where we are. The front part, the western part of the facility is heavily forested. So there's decent amount of forest between our property and the project site and the residents along Cold Brook Road. So I wouldn't be able to give you an exact amount of what the forest is out there, but it is heavily forested buffer between the road and the actual opening of the area that was clear cut for the car facility. I should note that we're not proposing to operate the facility outside really of the 18-acre footprint. So it would be our expectation, as we're seeing currently, that the area would naturally reclaim itself. There are decent sized trees that don't appear to have been harvested in the last 25 years within other parts of the property, which is what we would be supplementing with the 1 acre of preserved forest land post clearing.
Will you need to do any cutting that's specifically for the construction?
No, ma'am. The cutting that we've proposed is exclusively to accommodate the footprint of the facility.
Okay. In terms of the watershed, can you talk to us about a little bit more about, I understand that you're going to look at the wells and appreciate that condition, but about the watershed in general and its potential impact on water supplies for other areas as well.
That'd be a mark.
Yeah, I might defer that to Mr. Bergeron. But what I can say is, per the ERP, we're not proposing, and it's the OEMs and NFPA 855's standard to not saturate the facility with water. So that in itself would limit the amount of potential water that could seep into the ground.
What about the oil though? What if there's a situation where the fuel seeps out?
Yes, ma'am. We will be putting in place a spill prevention and countermeasure and control plan, an SPCC plan that would lay out very detailed, as with any other transmission facility or substation within the Commonwealth, how we would respond to that and what mitigation measures will be put in place. For example, secondary containment, lining of the underneath areas of those transformers and the like. With regard to the kind of the existing conditions on site. Yeah, we have worked really extensively to try to make most of the project outside of the protected water resource areas. So I'll let Mark Bergeron speak a little bit more to that, but it's our plan and it's industry best management practices, and it's a requirement per regulation to have an SPCC plan in place that would address specifically that concern there.
Mr. Bergeron, would you like to add anything?
Yes, thank you. I'll just add for context, the entire project site is located within the Chicopee River watershed, but it is split between the Ware River and the Quabog River subwatersheds. And so the portion of the project that is in the Ware River watershed, which is the eastern portion of the project site, or this portion closest to Cold Brick Road, is within the Ware River, and that is part of the Quabbin system and the protected water supply. The western portion of the site is located in the Quabog River subwatershed, which does not contribute to the Quabbin River, so it's on the other side of the divide. And so that all of the electrical equipment has been sited on the site to be outside of the Ware River and within the Quabog River. So it is outside of that particular surface water protection zone associated with the Quabbin.
I mean, maybe I don't understand how the water works, but there's no like line where you say, okay, now the water isn't going to go, it's going to go to one watershed and not another, right? I mean, I guess maybe I don't understand how the water works.
Sure. You know, it's driven by topography. You know, water when it falls on the ground runs downhill with gravity, and so watersheds and subwatersheds are divided or delineated, demarcated by topography, and so based upon engineering, the state's identification of where that watershed divide is. An on-site analysis, it was determined we know where the watershed divide is. We know where a drop of water will go, where groundwater tends to go towards one area or the other based upon topography. There's a break in the middle of the site where topography rises up and then back down. So on the western portion of the site, water will go towards that Quabog subwatershed, and on the eastern portion, it will go towards the Ware River, which contributes to the Quabbin.
Will there be any changes in the topography base from the project? Will you be doing any clearing that would change that topography?
All of the grading has been done such that we are in the other watershed, the Quabog, so the outside of the public water supply watershed. And the only activity proposed within the Quabbin River watershed or the Ware River watershed is the access road, improvement of an existing gravel access road, so minor, and the project will comply with all appropriate stormwater management standards.
Okay. About traffic. So I understand that the majority of the traffic associated with the site is going to happen during construction. Is that right?
That's correct.
So the community has expressed concerns about various issues with respect to traffic. So could you talk to us a little bit about some of the issues that have been raised and how they're being addressed?
Yes, thank you for that question. We have proposed to access the site from the north off of state highways. This route was proposed for multiple reasons. One, to ensure that we're able to access the site properly with the turning radiuses associated with the trucks and equipment that's needed to deliver the various components and construction equipment to develop the site. As well as to ensure that we are avoiding the concentrated area of more or less downtown Oakham. Some of the concerns that were raised by the town were around disturbing the school, which is approximately a little over 1 mile away from the site to the south. So we have designed it and implemented the traffic plan to ensure that we wouldn't be driving through or by the downtown area or the school. That was the main concern that we've heard. Of course, associated with the roads themselves not being able to support the equipment.
And I understand there's a commitment to repair the roads to the shape that they are in today, or a better shape than they are today.
That's correct, ma'am. Yes.
Better?
Yeah, it would be better. And as we've mentioned, we're of the understanding through various public documents that the town has plans to pave and redo the Colebrook Road. So we would then obviously be working with them to ensure the timing is correct, and if there is any sort of damage, we would then be taking care of that. One way we propose to do that is doing a and then post-construction survey of the travel route along Coldbrook Road.
So Commissioner Heibel had talked to you about the noise. I just want to say that people move to these areas because they're quiet and because they're wanting to be in a rural area. And that's sort of what they were planning on when they moved there, right? So understood that at some time there was a use there that I'm sure was not pleasant either. And happy to hear that we are going to clean up the whole site. Was not pleased to see that we were not going to clean up the whole site. So now I am pleased that at least there's going to be remediation on the entire site. But in terms of operational noise, how often are you going to test to see what the status of the noise is?
Yeah, it's our expectation that after the post-construction noise study is done, that would represent the worst-case scenario. We would be running all of the batteries full power for that study, presuming that the pre-studies are accurate and that's confirmed and validated by the post-construction studies. It would be our expectation that there wouldn't need to be any issues because of the fan throttling and because of the fact that these noise studies represent the worst case scenario, again, running the facility at 2 a.m. in the morning. And then thirdly, it's been an industry trend and one that the OEMs hear quite clearly from developers like ourselves that the equipment will continue to get quieter as the future batteries are developed. So we don't have a concern given the level of conservatism that went into the model that we wouldn't be able to comply with the DEP noise policy.
So right now, you don't have any plans to do any further testing beyond that first test afterwards?
That's correct, ma'am. At this time, we wouldn't anticipate the need to do ongoing testing given that, given what I just said. Yes, ma'am.
Well, what if the neighbors feel like the sound is louder than it should be? What are they supposed to do? Are they going to call someone? Like what do they do in that circumstance?
Yeah, I don't want to speak for what neighbors would do.
What would be the options that would be available for them to help?
Yeah, we would have a community outreach plan that would lay out how we would address those sorts of issues. Of course, they always could go to their elected officials who we would work collaboratively with to ensure that we're explaining that, what we're actually seeing and how the system's actually operating. Everybody's got a different threshold of what they think is noisy and what is not noisy. Everybody hears differently. I personally have pretty poor hearing, but others have really great hearing. So it would really come down to the data and explaining how the system's operating, how the sampling has been done and the monitoring has been conducted, and then really just working through that data to ensure that we're within compliance of the policy.
Are there any options in a circumstance where on an individual property?
On individual property to
Meaning,
ensure
is there any
it's
mitigation
quieter.
options? If in a particular location it is louder than we thought it was going to be, is there anything that one could do to help a particular property owner help with noise on their particular piece of property?
I think typically one would pose like reduce that noise. In this situation, given how dense the forest is all around and the distance, frankly, between the site and these noise sensitive areas, I'm not sure that would be appropriate like it would be in a more urban area.
Would the company be willing to discuss with the neighbors some options for their particular properties?
Yes, of course, ma'am. We want to be good neighbors. We recognize that this facility is a long-term investment in the Commonwealth as well as in Oakham, and as such, I think any developer standing here would be foolish to not acknowledge that fact. And I think that would not be a problem at all.
All right, that's all the questions I have for right now. Thank you. All right, we thank you, Mr. Kaplan and team. We'll now hear from the town.
You don't want to hear me twice, so am I on? Okay, great. Good morning again, Madam Chair, members of the board, both present and online. I'm George Pucci, and I represent the town of Oakham. I'm going to try to speak as briefly as possible because you have many people that would like to speak, including, I don't know everyone's names from Oakham. I know Mr. Broderick is here and has quite a bit of information to provide to the board and would like to speak. So I'm going to try to cut short the time that I have.
We appreciate that.
present to
We're
you.
interested in hearing from people as well.
I appreciate that. And also I should note, council is perfectly comfortable with you having a direct dialogue with anybody here. I don't, the questions don't have to come through me. So I didn't think I'd get into issues like this because it's not the proper forum, and I'm respectful of your time to get into evidentiary issues and what substantial evidence on the record shows. But I would respectfully submit it doesn't show what's being represented to you. And I want to start out with, on those issues, just a couple of biggies. The question about tying a BESS facility to solar. If there was a permit application for a BESS facility tied to solar, it's an as of right use that they're seeking a permit on. And I represent a lot of municipalities. I can tell you we take an approach because this is a protected use, solar under the existing Dover Amendment. And what I always recommend to clients, and I'll represent to you today, is you focus on conditions to allow that project to go forward. You don't do denials of as of right site review when it's a permitted use, such as a BESS facility tied to a solar facility. The representation that the evidence showed otherwise, that the town said no, they wouldn't permit it, is totally taken out of context for the way the question was worded in the discovery. But I can represent to you today, and I'm sure the town would be happy to reaffirm that, of course, the town would entertain the permit application in a good faith manner and recognizing it as site review for an as of right use. So my prediction would be that would be a permitted project. And just one other issue on that, on the trees. Now we're talking, it's approximately 5 acres of trees. Before it was approximately 6 acres of trees. And they distinguish between, mature forest versus an area that was previously cut down, but it's been growing for 25 years. 25 years is a long time. Query, and without getting rhetorical, we're talking about the 2024 Climate Act. Why do we have to pick a site that involves any type of tree clearing to that nature? Why don't we pick an appropriate site for a large-scale industrial use, such as an industrial zoned area that doesn't involve cutting down trees that have been growing for more than 25 years, especially in an environmentally sensitive area that this is in. And back to, so just staying on that theme for a moment, I'm not going to get into with you about legal issues in opposition to the project, whether it qualifies under the Climate Act, whether the burdens were accurately applied. But I would say the town has a lawfully enacted moratorium against large-scale BESS facilities that are not tied to solar. It was lawfully enacted. It was approved by the AG, then AG Healy, who is now Governor Healy. And I understand that, the AG's letter has a little caveat about energy projects. It does have that in there. But I would question if the real intent was to just simply ignore the moratorium that was approved by the AG, why approve it? So, and this wasn't something that was enacted in response to the Moraga project. This was part of the town's planning efforts, recognizing that this is a rural residential area. The only thing that Oakham has left is peaceful quietness, forested areas, and the rural residential character of the zone. There is no precedent for taking a case that doesn't even allow an industrial use as a permitted use under zoning in a rural residential zone, which the entire town is, with a moratorium against this specific facility. It's like the company almost purposely chose to pick the worst municipality out of 351 cities and towns to propose this project. So just summing up on that issue, when it comes to legal issues, and respectfully, if the decision goes on to approve the project, we're upfront about it. The town will pursue any and all good faith arguments in response to the decision. We will file an appeal. We will argue those issues on appeal. We're not going to get into them today or back and forth about the merits of those, but I just want to be upfront about that. Our focus on our comments on the conditions were, conditions that would help augment this project if ultimately it does go forward. I should note to you that there's a difference between the general opposition of the town to the project and that we will pursue good faith arguments, legal arguments in response on appeal with the issue of conditions. We're not seeking to apply overly burdensome or unreasonable conditions as a way of submarining the project. There are two issues. We're going to pursue any avenue of appeal on good faith legal arguments, but we're also going to try to get reasonable conditions in the event that this project is ultimately allowed to proceed. So the purpose of the conditions that we proposed are not to submarine the project, they're to properly condition the project. I just want to be clear about that. One of the, and I appreciate your time and that you have access to the written materials. We've submitted detailed written comments requesting additions to those conditions. Biggies that I would point out are a full assessment and remediation of the property prior to any site disturbance related to the project. That's crucial. And it's not a matter of that there is a few things left on the site. It's being revealed that there were things buried. So, you can just go around the perimeter of the site in these areas and you can see partially buried materials. So, and I heard the comment from the secretary, it's somewhat incredulous that this is not a brownfield site, quite frankly, despite the assessments that were done previously. So we would expect a robust, full environmental assessment with an LSP. We requested funding for a peer review LSP to go ahead with that remediation plan before any site disturbance related to the project. That's a crucial condition. The way that the tentative decision had it was that it would take place after the project is constructed. That would be totally unacceptable. And I just want to touch a couple of issues following up on that, on the site assessment. The town has good reason to be skeptical about representations from the company. And we understand this is America and they're allowed to proceed and try to make money on a project, but they have not been in good faith or upfront with the town about these types of issues. Under oath, the company testified during the evidentiary proceeding before the presiding officer and staff that they were responsible for this ongoing condition. They were going to file a notice of intent. The people that the town should be in contact with are the company concerning these issues. They never filed that notice of intent that they promised. They filed a limited notice for the access road, but they didn't file anything related to these remediation issues that they had promised under oath. The town then, the Conservation Commission, which is the first line of defense in these matters, filed an enforcement order. As a result, council refers to a 60-day deadline that the commission somehow had to comply with. The commission ordered in the enforcement order compliance by a date certain. The company refused to comply with it, and then they filed suit. The 60 days that they're referring to is 60 days to file a cert action opposing an enforcement order in Worcester Superior. We fully expect that the Worcester Superior Court will affirm that enforcement order and order injunctive relief for the relief sought therein. I'm at the end of my time. I briefly just wanted to touch on noise. We can't get into this today, but cross-examination established that noise was not adequately assessed. They didn't address, I forget how many out of, say, 12 out of 15 sensitive receptors. Uh, Everything was very on the line, the 40% throttling, despite the fact that in the summer months, we all know what the summer is like now in New England, with the sun bearing down on it. They're not going to be able to do it at the 40% throttle. They don't know two of the three noise producing components. And I'll let the residents speak to it, but there's no question that this is going to have adverse impact on residents in a rural residential area who have reasonable investment-backed expectations that they will continue to be in an area that they bought into and plan to build their lives around. So I'm beyond my time. Thank you very much for listening to me, and I wanted to also thank the presiding officer, staff, and council. They were extremely collegial during the process, and we're very appreciative for the treatment we've received, even though we respectfully disagree with the result. Thank you very much. And I'm available here if you have other questions.
Does anybody have questions, or should we move on? Ms. Hypo.
Thank you. That was very helpful. Just two follow-up questions. When you mentioned the concerns about the 40% throttling in the summer months, is that because of heat concerns, or what's that based on?
Correct. And I would commend you actually to the transcript. There's that 40%, it's based on an assessment of a temperature range that was taken like from Worcester Regional Airport. But query, and again, I don't want to be sort of anecdotal. I mean, I remember last summer, we had many days that, I'm not in Oakham, but we had many days with oppressive heat and humidity and beating down sunlight. And that's going to be directly on these BESS units that are exposed, to the sun in the summer. So we did question, and we cross-examined on that issue, that they're not going to be able, they're either going to have to shut down or they're going to have to throttle up. And that's one of these issues that, everything is on the edge. The 40% is right at the edge to allow them to comply. Certain borders that they did the noise testing, the ambient testing, and then the modeled results. Some areas do exceed the noise policy. Then areas, within reasonable proximity of it somehow are just below, the ambient level. So everything is like that, just on the edge. And I'm not saying it is fraudulent, but it was very much on the edge and taken in certain areas to end up with this result that this project will comply. But everything was, right at the edge. So if it's the 10 dBA where they found it would comply, was like 9 dBA over. And, again, these are areas that are completely quiet, rural residential areas. One of the residents is here and he's represented by council. I mean, this is an area that they're not used to hearing, nor should they be reasonably expected to hear noise and humming. That's really the thing too. Aside from the noise, there's two levels of the sound travel. The other is that hum that they don't experience. And that's going to happen. And the other thing about it is, the depressed project site, the noise is going to go up. There's nothing that's going to be able to adequately buffer that. A sound wall is not going to work. And we all know that vegetation doesn't work for it either. Fact is, this gets built. We all know what will happen. It'll be a constant enforcement headache. Residents will be calling the town. The town will be calling the company. It'll be like that. And it will be misery for everyone involved in it because the thing is built and nobody's going to want to shut it down at that point. So then we're dealing with a problem that was permitted based on very close modeling results for everything.
Thanks for that. One other follow-up. You mentioned earlier in your remarks in regard to the tree cutting that this is an environmentally sensitive area. You say what you mean by that?
Just because of it being in the watershed.
Okay.
And, the wildlife habitat, I have to comment again, things change when they're not under oath. But when they were under oath, Mr. Bergeron was very clear. They were going to do a wildlife study. The company mentions the ORAD. The ORAD omitted wetland BVW on the site. It omitted vernal pools that the state subsequently certified. When we were in the hearing, which was, an intense hearing, evidentiary hearing, we were talking about these issues, and it was contemporaneous for when you do a habitat study related to vernal pool impact. And Mr. Bergeron, I know him. I believe in his professionalism. He's a qualified professional. And there was no doubt about it. He testified under oath. They were doing a wildlife study related to this, and that would be submitted. Now today, we hear, oh, well, that wasn't needed. Well, that's not what you said 2 months ago when we were under oath.
Thank you.
Thank you
very much.
All right, representative parties?
That work? Thank you. My name is Kenneth Reich. I represent, along with co-counsel Stephen Ferry, who's a professor of energy law and environmental law at Suffolk University, and has been there for teaching for about 40 years. We both represent the represented party interveners. There's 7 of us, not 6 of us. 7 of them, not 6 of them. It's Clayton Rice, Michelle Bertrand, Sharon and Scott Corey, James and Daniel Stevens, and all but Mr. Rice are direct abutters of the site. Ms. Bertrand lives on the other side of the site from where the Stevens and Coreys live. They live on Colebrook Road, the road that was mentioned that goes right next to the site, and where the big trucks would be turning on a very tiny driveway to get into the site. So first question procedurally, I'd ask that any questions that the panel has, including on the screen, that those be directed after both Mr. Ferry and I present, because we're only limited to 5 minutes. And I'm only going to take 4 of it because some of the larger issues that we want to direct, Mr. Ferry will take. So could I just request
Fair enough. Go ahead.
Okay, fine. This doesn't seem to be, you can hear me all right? Okay. So I wanted to correct a couple of statements that were made both by the presiding officer and by representative of the company. First of all, presiding officer stated that this project began in November of 2022. In fact, Moraga did not come forward to any governmental body or publicly in any way about this project until either late 2024 or 2025. So, but they did have control of the project and project property through 2 agreements that we were never allowed to see, that gave them an option to purchase and did give them control. And again, since we were not allowed by rulings of the presiding officer to see those documents, I can't tell you, we can't say what the extent of the control is, but we do know they had control. They did have an environmental person on the site back in 2022. Secondly, the environmental reports that were supposedly relied on by Moraga, pardon my French, they were a joke. One was commissioned by the former owner of the junkyard so that he could, give something to the people that were going to buy his property. There was a second one commissioned by the company. None of them did any extensive sampling. In fact, it looked like the sampling was directed at not finding anything because all they looked for was oil. They didn't look for any other hazardous waste or anything that would, result from an operation of an auto junkyard. So those can't be relied on as even phase 1 reports, certainly not phase 2. So when they say they relied on those reports were totally inadequate. And I, as an environmental lawyer, would never advise my client to make any judgment based on, those kind of reports. Thirdly, there are tremendous gaps in the in the record. And the tremendous gaps are due to two things. One, the company consistently and universally either filed documents late, expert reports late, did not respond adequately, or sometimes didn't respond at all to questions. For instance, can you name any other sites that you have control over in Massachusetts with the best, with the best facility? They did not identify the Tingsboro site, even though there was already a DPU application that we had to dig out of the files. That was never provided us. We dug it out, showed that they did have an application for some amount of megawatts for that property. There were no environmentally sensitive conditions in Tingsboro compared to this site. This site is as Mr. Pucci said, this site is the worst possible site in the Commonwealth of the 351 towns where you would want to put this kind of a facility. A, it's very small. B, it's very rural. C, it's sitting right on the watershed of two major reservoirs. 4, as has been testified, there are wetlands all over the site. 5, there's vernal pools. There's other habitat that have lived in this site or have are on this site, all of which would be endangered if not destroyed by the project.
He asked me to tell him when his 5 minutes.
Are they up? Oh, all right. All right, I'll just make some very quick points. There are major procedural errors made by the presiding officer in handling this particular project. As I already said, he consistently denied every one of our major and material motions, basically to try to get into evidence that had been withheld by the company. Every one of them was denied for whatever reason. Secondly, we talk about fire hazards of the BESS. Their safety expert testified extensively about fire hazards from Tesla facilities, had a chart showing major facilities around the world that had fire or water or other problems. And C, he testified, or another company representative testified, that there were probably at least 30 major battery storage incidents in the last several years. I don't know if it's specified several, 2 or 3 years, but this is an emerging technology and it's not totally proven. You don't put that in a very rural area and endanger those people. And I represent interveners who have all testified, put in comments. I urge you to look at their comments. They're very persuasive about what's going to happen to their project. Thank you very much. And if I'll be happy to address other questions after Mr. Ferry's.
Okay.
Thank you.
Good morning, Madam Chairwoman and members. My name is Stephen Ferry. I'm a professor here in Boston, and Mr. Reich asked me to assist him a bit in this.
Can you just make sure you're speaking into the microphone?
I'm sorry. Okay. With the limited 5 minutes that I have, I would like to, if I could, just address 2 issues that were raised earlier, which is on site selection and noise particularly. Let me say first, there was a question also about the amount of trees to be cut down. Was it for construction? The answer was no. In the hearing transcript, the witness for the company, and asked exactly how big the footprint is for the battery storage and the transformer, agreed it would be approximately 2.5 acres. So there's probably some laydown area involved. That's just a small point. Let me say also, there are right on the, I think of it as the west side of the property, but on the west side of the property, abutting the property line are 6 long inhabited residential dwellings. There was a mention that they are only some are only a quarter mile away, some are a third of a mile, but a quarter mile is once around a track. It is relatively close. So let me first, if I could, just quickly address the siding issue, if I may. I know there were some questions on that. On the siding issue, the draft order now says that the represented interveners wanted the best site. That's not true. There's no citation to the record. What the interveners suggested was appropriate in every EFSB proceeding. if there were at least 4 viable sites, bring forth 4 viable sites and compare 4 viable sites. The other 3 sites were immediately dismissed. The application, which was quite long, spent 1 page double-spaced on each of those, sort of saying, well, it's further from the transmission line. Well, there's not enough acreage. You certainly are a lot of sites. That during the hearing was only obtained during cross-examination when the cross-examination asked the company, asked Mr. Benito, how much access do you need to interconnect with the transmission line? And the answer was, oh, those are only a few inches wide. And so the next question was, well, is 100 feet enough? Yes, oh, that's more than enough to get up there. Then there was a long series of questions looking at how many places are there in Massachusetts where you could put the perhaps 2 dozen or 3 dozen best facilities that the state is looking for to meet its goals. The cross-examination had to do the math. The company, Mr. Benito, agreed to every one of these that it seemed to be more or less correct. But basically the answer was, assuming you could approach from either side of a transmission line, there were 440,000 places in the Commonwealth with a existing large transmission line that could at least be a potential site. Not that any huge amount of them would work, but that's a lot. If you came at them, the company said, well, we prefer to come from this particular side. So that was then cut in half and said, was that roughly 220,000 sites that could have yielded the 4 viable sites? The answer was yes, we think the math is relatively correct. Then there were a series of questions of what other sites did you look at? The other 3 sites were dismissed in a page, double-spaced. Oh, it's too far from the transmission line. It's not enough acreage. If you read the transcript or if you read the briefs of the represented interveners, there's a go-through where a number of questions are asked. Did you look at waste-to-energy facilities? Did you look at all these towns that are requesting storage? Did you look at existing shut-down power plants? Did you look at existing renewable plants? It got more and more finite. It said, okay, you've got 3 other sites you've dismissed within a roughly 12 or 15-mile radius. Let us give you some other sites in those towns. And then basically in this inquiry, there were several dozen sites suggested where there were requests for battery energy storage facilities. Did you look at this site? Did you look at Leicester site? Did you look at Sterling? Did you look at Princeton? We took all the towns within about a 12-mile radius and said there are requests for battery storage industrially zoned in some of those areas. Finally, the question was, let's look at the East Brookfield community immediately adjacent to the town. Are you aware that there are 2 6-megawatt solar projects that have been operational for more than 10 years? They're sitting on 150 acres. They're in a quarry, so there's no need. 2 solar projects use approximately 30 of those 150 acres. And the developer of that project says there's plenty of space for a very large BESS facility there, and it could store the solar. So to every single question, did you look at this on dozens of other sites that the interveners asked about? And again, it's the company's choice of which it puts up. The answer was no, we didn't look at any of those. Any sites that already have substations to lift the power? No. Any stations that are close power plants? No. So there are a large amount of these. Again, we did not ask, or the interveners did not ask for the best site. They just asked for 4 viable sites. Every other EFSB facility that I'm familiar with has even stopped proceedings to allow the applicants to come up with 4 good sites or viable sites if those exist. Let me say one other thing about site selection, if I may. Kingsborough. We asked the question of the company. Do you have any other projects in Massachusetts that are publicly disclosed? We don't want anything private, publicly disclosed. No. During cross-examination, there were many more questions. Anything else? Mr. Benito, are you sure there's nothing else? No. The interveners then had to produce a document that we eventually found after a lot of look from the DOER website. That was the application for the Kingsborough facility of the same parent company. That is a facility that's industrially zoned. The community is perfectly happy with it. It's not near any residential housing of any sort. It's in an always industrial zone, and it's being more or less welcomed into that community. The Kingsborough facility, we then produced this, and we said, can we show you this? And the response was, how did you get that? And I said, it's a public document. We only ask you for it. It's been available from DOER. Mr. Benito, did you prepare this? Yes. Okay, so that was introduced into one of the 2 pieces of evidence. At that point, Let me just go a bit longer and say one word about noise, if I may. At that point, we talked about Tingsboro. We said, how large is the Tingsboro facility? We refused to tell you. We said, would you turn to page blankety blank of this public document that's redacted from DOER? It says it's 500 megawatts. Is that the correct size? Again, there was a lot of difficulty getting this out. Then we said, how big was your award from DOER in Tingsboro to be a state site that has been selected of the 4 sites that were selected for other potential ratepayer subsidy? And there was a refusal to specify. So cross-examination had to do the math. We said there, 1,200 and some odd megawatts. The other 3 entrants have disclosed the amount that they have won, 700 megawatts in Everett, 300 megawatts there. That leaves 150 megawatts to make the total. Is that how much you were awarded?
We need you to wrap it up.
Okay, we
Thank
refuse
you.
to tell you. And so basically what this means is the Tingsboro site, which checks off all the boxes on the DOER application, which this site will fail every one except close proximity to the power line. That Tingsboro site has 3 out of its 500 megawatts, with only 140 committed so far to the state through DOER. It has 350 megawatts available. That will take this 180 megawatts. Our suggestion to you on this is that you should have the applicant put the rest of that facility in and this facility to the DOER. If it is selected, make your award of building this site, which is going to fail on most of the other criteria, we believe, contingent on first exhausting Tingsboro as the first site, and come here only if it is selected by DOER as meeting the state's goals for a certain amount of contracted capacity. We know that goal is quite large now at 10 megawatts. So I'm sorry that I went a bit over. If I could just say one thing in 30 seconds about noise. And again, I would urge you to ask me more questions about any of this if you would during the question time. The key issue is there was selective sampling, I think, as Mr. Pucci just said. The Stevens property, which is the closest abutting property, whose backyard is the property line with this site, there was not a noise monitor put there. Instead, they moved it a fair distance away up to the street, which picked up more ambient noise, which raised the ambient level, and therefore makes the 10 decibels have a higher starting point. There's much more we could say about noise and other things, but let me end there. So thank you for the time.
I think let's see if there are any questions for the attorneys. So I think we should take a 5-minute break, let people stand up for a few minutes, and then go back to hear from people. We're going to go off the record. Thank you.
Okay. Doesn't matter. Read this. I remember this too. Oh, yes. They said.
There might be.
But
Okay, we are now going to ask whether any of the interveners, the people who are represented, would like to make a comment themselves. So the first one that I have on my list is Michelle and James Bertrand. Is that pronounced correctly? They're on Zoom. Okay. Okay, we're looking forward. Thank you. Sorry, how do you pronounce it? Thank you, Bertrand.
She's on Zoom, but she hasn't raised her hand. Do you want to ask her if you're online? Please raise your hand if you'd like to speak.
And it's fine. It's fine if she does not. Well, why don't we move on to Sharon or Scott Corey? Ms. Corey, I'm sorry to bother you, but can you just put that a little closer to you? Just want to make sure the people on Zoom can hear you. Can someone give Ms. Corey a hand, please?
I'm Sharon Corey. My husband Scott and I are direct abutters to the best project being proposed at 358 Colebrook Road in Oakham. Our house is about 1,200 feet from the site. On page 135 of the EFSB tentative decision, Mr. Kelleher states, the siting board finds that a grant of comprehensive zoning board exemptions would avoid the substantial public harm of delayed construction or operation. Substantial public harm. On the contrary, the permitting of this project will cause substantial harm to me and my husband and my neighbors on either side of us and across the road. We are the public who face substantial harm if this project is permitted. We're being treated as collateral damage by both the company and the siting board, it seems. We face substantial harm in both the construction and the operational phases of this proposed project. During construction, a potentially 2-year process, we face the possible poisoning of our well due to the disturbance of contaminated soil on the project site, which is a former junkyard and now a toxic landfill. The property sits very close to the central footprint of this project. The construction of an industrial scale facility of this magnitude would surely produce loud noise and heavy traffic. The planned deforestation would destroy a sizable amount of wildlife habitat. Because we are in such close proximity to the proposed site, the operational phase also poses its own set of potentially substantial harm to us. Number one, the threat of thermal runaway and its disastrous effects, including the release of toxic chemicals into our immediate environment should a fire occur. Number two, should a fire occur, the emergency response capacity of our part-time fire and police departments may not be enough to contain or extinguish that fire, threatening our house and threatening our property. Number three, because of the incomplete noise analysis that was submitted for the record, we don't know how loud the noise will really be. We don't know if it will be tolerable. We don't know if we'll be able to open our windows or even sleep at night. Of course, I don't want this in my backyard. Would you? The board seems to be more concerned with the company's financial loss than about the financial hardships that we have already endured and the substantial loss of value to our home and property if this project is permitted. We've suffered a significant amount of stress and anxiety related to the disruption of our lives and the very real threat of disaster just feet away from our home. Article 97 of the Massachusetts Constitution states, and I quote, "The people shall have the right to clean air and water and freedom from excessive and unnecessary noise." and the natural, scenic, historic, and aesthetic qualities of the environment, I suffer from post-traumatic stress and deliberately chose the naturally quiet and peaceful life that living in Oakham affords. I find comfort and enjoyment and a sense of well-being by spending time in nature. It's quiet here. It's quiet enough to hear the early morning birds and the evening songbirds, the call of the owls and the howling coyotes at night, quiet enough to hear the children laughing and playing in the schoolyard, not a mile away, 2 doors down from my house. In my yard, I've seen bear, moose, deer, coyotes, fox, bobcat, porcupines, eagles, hawks, falcons, herons, and hummingbirds, and snapping turtles who live in the small pond at our property's border, which abuts the proposed site. Members of the board, I implore you, please don't take all this away from me, away from my husband, away from my neighbors, and away from my community.
Thank you very much. I'm sorry. Clayton Rice? Would Clayton like to speak? Can you state your name, please?
My name's Scott Corey. I'm a direct abutter to the proposed project site. The site is unfit for development because it is contaminated. The site's former operation was a junkyard where customers and employees pulled parts from junk vehicles. Hoses and brake lines were cut, releasing fluids directly into the soil. Cars were routinely flipped on their sides or roofs to access undercarriage parts, again, releasing fluids. No effort was made to keep these petroleum-based products from seeping into the ground, where they remain today. This happened for over 50 years. I witnessed it. I saw it. The possible contamination of our well is a real threat and a valid concern. These chemical compounds move through the groundwater, which the company says is high on the site. The entire site should be soil tested before beginning construction, so everyone, including the company, knows exactly what contaminants remain in the soil. I know what's down there. I witnessed it. The siting board assumes that the DCR will approve the project moving forward, but apparently the DCR has its own concerns. Contained in an email captured by a public records request, one DCR staff environmental analyst 3 writes on March 3rd, 2024, quote, boundary lines were fully blazed and tagged today. Plenty of unmapped wetlands and streams on that private parcel. Literally tons of exhaust systems, batteries, glass, alternators, tires, wiring. Tires on the DWSP along the northern boundary on the eastern side, just west of the power lines. That's watershed property. Is it not the responsibility of the EFSB and other state agencies to ensure that the proposed site is thoroughly vetted? Now I would like to address the topic of community outreach. And definition of community is a body of people living in the same place under the same laws. Although the company claims to have reached out to our community, it's unwilling to honor or respect our community's laws. I'm going to skip over that little part there. Mr. Kelleher refers to the undue financial burden that would be placed on the company if not granted a total exemption of local bylaw. We have spent thousands and thousands of dollars trying to protect our drinking water, our property value, and our health. Have you ever considered what we've gone through, not only financially, but emotionally? The first thing I think of in the morning is this project. The last thing I think of at night is this project. If I wake up during the night, I don't go back to sleep. This has affected the quality of my life already. Before any ground is turned, before my well gets contaminated, I've already been affected by this. Your lack of compassion and consideration for other human beings is disturbing. To Brian Benito in Rhineland or Zoval or Moraga or BHT or whoever you are, I would like to say, as Jesus said, go where you are wanted.
Thank you. Clayton Rice?
We have somebody on Zoom that's iPhone 2. I don't know if that's Mr. Rice. Then Michelle Bertrand has her hand raised right now.
All right, why don't we hear from Michelle?
And in person, we have both the Coreys as well.
Hi, my name is Michelle Bertrand, and I'd like to say a few things. I live on 472 North Brookfield Road. My property will be behind this project. The site where the project will be built is the southeast corner, is not where the cars were kept, which one of the board members was asking. It's in the 25-year growth forest, which the company plans to cut down. It's next to the high tension lines where the forest will be cut down. So the volume of the noise, the humming, and the fans will travel down the high tension lines towards my house. No one's worried about the possibility of contamination of Boston's water supply. To build, the two retention ponds that they're going to have, one will discharge into the Ware River watershed, and one will discharge into the Quabog River watershed. Yes, they will be filtered, but if there's an oil leak, that water will be put into those ponds and it can't be filtered fully. There is a manual shutoff valve. That means the company has to come down and manually shut those valves so that water does not discharge into those areas. No one's addressing the noise for the landowners that abut this site. If the landowners would like to build closer to the site, they're told the sound study is where your house is now, not next to the boundary line. So if their family members want to build on site, they can't, because now they're going to be even closer to the proximity. And according to the sound study, it wasn't done when the project was created. So too bad. I've lived at this house for 31 years and I moved here for peace and quiet. I didn't mind traveling into the city to go to work. My husband's disabled and so am I. So we're on a limited income. And owning our own home is our future. That's our value. That's what we have left and nothing else. I asked myself, if a fire occurs, what will happen? Well, Chief Howe was told to stay at the road and let it burn. Who would know the woods are on fire? Well, I know a fire truck cannot access the rear of the project property because the company has no plans to build an access road around the entire project for such an event. There is no viable access for the fire department to access the high tension lines coming from North Brookfield Road, so they can't access the rear of my property. During testimony, Chief Howe stated, Oakham has no municipal water. We don't have hydrants anywhere in town. He also stated, my issue is we don't have the manpower. Everybody works outside of town. This is a volunteer fire department. When Chief Howe was asked during his testimony by Attorney Reish, do you have concern whether there's a best fire? You know, the worst case scenario that everybody is worried about, a forest fire. As a result, Chief Howe said, yes, I am. In testimony, Ms. Lowe asked, could you please describe or list what other municipal fire departments might realistically respond to a fire at the project site? Chief Howe said, we have a robust mutual aid agreement. We're all very small towns in the area, so we depend on each other regularly. Our basic working fire, we'd have the surrounding towns come, which would be Rutland, Barry, Hubbardston, and New Braintree. So I'm always struggling to get more than 5 or 6 people. Out of all those towns, we can get 5 or 6 firefighters to come to help. As of mutual aid, Oakham relies on Rutland will lose 5 or 6 firefighters as of July 1st. New Braintree and Oakham are volunteer. And usually those volunteers are working outside their community during the day, and some work during the night, so they can't respond. Barry has 2 to 3 people working their firehouse a day. And Hubbardston has 2 full-timers on shift. You can't leave your own town unattended, so maybe they can send 1 person. The second serious concern we have is about our water. I rely on my well water for drinking, bathing, and cooking. Heavy construction can disturb bedrock and affect nearby wells. Excavation, blasting, which they're not going to do, but they're talking about dewatering. Within a mile can fracture bedrock aquifers, redirect groundwater flow, or lower the water table, potentially causing a drop in the water pressure, cloudy water, or a dry well. The company noted that certain construction activities may require dewatering due to the high water table. My property is downhill from the site. I am very nervous, and my well will not be tested because I'm 6/10 mile away from the site. So I am only 1/10 over the half a mile that they will check. So if
Ms.
my
Bertrand, can you
is contaminated or the pressure drop, who's
Ms.
going to be?
Bertrand, hi, I'm sorry to interrupt you, but
an
can you,
tentative approval.
can you finish up,
Says
please? I just want to
according
make sure we
to
have other people have
the
time.
company, the town has no public water department, but has a limited number of public non-community groundwater wells. Oakham has approximately 687 homes that rely on wells, and we have 2 campgrounds. So every home and business in Oakham will be in imminent danger of losing their water supply. Who will be at fault? The company, the state? Who will help the residents of Oakham? How long will it take to build water supply for Oakham if we get contaminated? The third concern is noise. Living in such a rural community, we enjoy the peace and quiet. Listening to the birds, crickets, frogs, etc. is so relaxing. Now we live in fear of what an extra 10 dBAs will sound like at all times. Will I be able to keep my windows open at night or even during the day? Will the company comply with the sound levels? Who will make the noise? Make sure the noise does not exceed the 10 dBAs from ambient. Between the fire and water risk and constant noise, once the project is up and running, how much value will I lose in my home? My home is all I have that is valuable. This is my life savings. How can Moraga in good faith say they looked at 4 sites when selecting 358 Colebrook Road? The 3 locations were non-viable options. Matter of fact, one was on Crawford Road across the street from me. And that was a campground. And I've talked to the owners. They were never even notified that this company was even looking at this site. This project is taking away home rule. Oakham is the only town in the Commonwealth that has the bylaw against standalone.
Ms. Bertrand, can you hear us?
I voted for this bylaw with the majority of the town residents. The Attorney General at the time, Maura Healey, approved it. By allowing this project, the EFSB and the Commonwealth are telling its residents that Oakham vote does not count. I thought every vote's supposed to count. No amount of money that Moraga gives to this town of Oakham would be enough. This huge project will forever be a blight on the town of Oakham with the noise, fear of fire, a smoke plume, and possibly contamination of our water and the water of the MWRA. I am requesting that the board deny this petition. Thank you.
Thank you. Go ahead.
Do you guys a favor and I shorten mine up?
You're Mr. Stevens, correct?
My entire statement, I'm hoping goes into the docket at some point, but I haven't seen it yet. So my name's James Stevens. I live at 360 Colebrook Road in Oakham, directly adjacent to the project. I'm deeply troubled by several of the findings in the presiding officer's report because disputed claims are presented as established facts. First, the report states that 2 swept path analyses were completed. In reality, the first submission was not a complete analysis, and even the second failed to demonstrate a critical maneuver that interveners repeatedly requested: a truck exiting the site and making a right turn onto Colebrook Road, Despite that missing information, the board accepted testimony that entering and exiting the site require identical turning movements. Given the public safety implications, that conclusion remains unsupported. Second, the report minimizes concerns regarding the encroachment of the site's access road on my property. Whether an encroachment has existed for years does not determine whether it is lawful, acceptable, or without impact on neighboring landowners. More broadly, this project is being compared to uses that no longer existed when my family purchased our home. Before buying, we carefully researched development risk, Oakham's rural character, privacy, and quiet environment were extremely important to us. We were assured that local bylaws protected the community from this type of development. We invested everything we have into our home based on that understanding. I'm also concerned that the applicant and its consultants have not demonstrated the transparency residents deserve. Significant questions remain regarding environmental disclosures prior to representations made to local boards and the accuracy of information presented throughout this process. Most importantly, I do not believe sufficient weight has been given to emergency response concerns. Oakham has no municipality or municipal water system and relies on volunteer fire department. Training alone cannot create water infrastructure, equipment, staffing, or real-world experience responding to a large-scale battery fire. Residents deserve confidence that emergency services can protect lives, property, and the environment before a project of this scale is approved. My family is not opposed to renewable energy. We are environmentalists. We have solar panels on our home. Our concern is not in my backyard. Our concern is that projects like this must be located where infrastructure, emergency resources, and surrounding land uses make them appropriate. Respectfully, I ask the board to reconsider whether granting multiple exemptions from Oakham's bylaws truly serves the public interest and whether the project belongs in a quiet rural community when more appropriate locations exist. Thank you.
Thank you. And Mr. Stevens, just so you know, we do have a copy of both you and Mrs. Stevens' comments. So thank you.
Thought I'd shorten it up.
No, I appreciate it. We do have the full comments, and all the comments that have been sent over the last couple of days. We do have the written comments and have read them. So, okay, who's next? Is Clayton Rice here? Oh no, do you want, please?
I'm Danielle Stevens. Thank you for letting me speak today. So I'm not going to read my whole statement since you have it. I just wanted to reiterate that this is not a routine project in a routine area. This is adjacent to the Ware River watershed, and it is half the state's drinking supply is at risk if one mistake is made. A lot of trust has been placed in the applicant and their thoroughness to comply with the regulations. And if you look at the initial petition, they stated very clearly that there were no vernal pools or vernal pool habitats on the property site. And they had several environmental experts down there several times. I reached out when I read it to the Natural Heritage Foundation, and I spoke with a gentleman over there, and he never even set foot on the property. He used public information and aerial photographs and identified several areas that looked like they could be potential vernal pool habitats. And that's without even setting foot on the area. Later, someone from town got those areas certified with the state. So I want to know if we're willing to put the trust of half the state's drinking water, if this is the investigation that they concluded just on the vernal pools alone. And the sweat path analysis, my husband already covered that. So they were getting credit in the tentative decision for submitting 2 sweat path analysis when it took 2 sweat path analysis to get half of one answer. That's all I have.
Thank you for sharing.
Clayton Rice is not here or raised his hand. So there are the Saupays that are other interveners as well.
Okay.
If the Saupays are online, please raise your hands. Do not see them.
So we will now move on to the limited participants. Does Eric Baldwin want to speak? Kathleen Dunn? And Langolis? Thank you. Okay, appreciate it. He's
See him
already
down
done
there?
her.
Sorry.
Yeah.
See him?
He's right under her.
There he is. Hand raised.
Yeah.
Good morning.
Okay. Good morning. Go ahead. Please state your name for the record.
Sure, Aaron Langlois. So my name is Aaron Langlois, and I'm a lifelong resident, or sorry, a 20+ year resident of Oakham. Cities and towns are on the front lines of climate impacts. An MVP helps communities identify vulnerabilities, engage residents, establish priorities, and implement resilience projects. Municipal vulnerability preparedness programs matter. Partnering with communities to build stronger roads, restore wetlands, plant shade trees, and make sure everyone has a voice in shaping a safer future. Secretary Tepper, these are your words, and we agree. We would appreciate your ongoing commitment to that. I'm an Eagle Scout, a lifelong committed person to the environment, a registered nurse and a former member of Oakham's Board of Health for 9 years, Board of Selectmen, and the Commonwealth's Local Government Advisory Commission. Most relevant to today's discussion, I participated in Oakham's most recent hazard mitigation plan update and the development of our first municipal vulnerability preparedness plan, both fully funded by the Commonwealth of Massachusetts. Those plans required our community to identify environmental vulnerabilities and natural resources, most critical to our resilience, to identify what should be protected. And Oakham did exactly that. Together, we identified forests, wildlife habitat, groundwater resources, open space, and other environmental resilience priorities. The Commonwealth asked us to do that work. It paid for that work. It approved that work. Yet, after reviewing the tentative decision, I cannot find where those priorities were meaningfully weighed against the asserted benefits of the proposed project. I cannot find where Oakham's environmental goals, climate resilience priorities, or documented vulnerabilities changed one single conclusion. The decision extensively discusses the statewide energy policy, grid reliability, and the asserted benefits of the project. What I do not see is a comparable analysis of Oakham's environmental priorities or an explanation of how those priorities were weighed against the project's asserted benefits. That matters. Because acknowledgement is not analysis. Listening to concerns of hundreds of people is not weighing concerns. Recognizing opposition is not addressing opposition. Nowhere in the tentative decision is there any explanation of why Oakham's environmental priorities should be set aside or overridden. The board states it conducted a broad and balanced review of the public interest and welfare. Respectfully, the tentative decision does not explain how the balance was reached. The board states that local issues should be resolved at the local level whenever possible. Yet, this decision would grant a comprehensive zoning exemption that overrides Oakham's bylaws and generations of local environmental stewardship. If local environmental and climate resilience planning matters, it must matter when it conflicts with a preferred project outcome. Otherwise, communities like Oakham and others are left questioning why they were asked to participate in the first place. The issue before the board is not whether climate action is necessary. The issue is whether small rural communities' environmental priorities carry any meaningful weight when they conflict with statewide objectives. The Commonwealth asked Oakham what environmental resources mattered. Oakham answered. The Commonwealth asked what should be protected. Oakham answered. The Commonwealth asked Oakham to identify its vulnerabilities, and Oakham answered. The tentative decision does not explain how Oakham's environmental priorities were weighed against the asserted benefits of the project. It does not show that Oakham matters. Climate resilience is not only what we build, it's also about whether we protect what we said mattered. Thank you.
Thank you. Sarah Peterson? We also have Mr. Lango's comments as well here. No, Miss Sarah Peterson.
Sarah Peterson has her hand raised. We're going to promote them. And then the Barbara Piucci is here. And I believe that's Vincent Piucci. Okay, they're both here. And we have a number with their hand raised. I'm not sure if that's the Mr. Baldwin or not.
Why don't we go with Miss Peterson? Your hand raised.
Thank you. My name is Sarah Peterson. I reside in Oakham. Dear members of the Siting Board, with all due respect for the decision that is being made regarding Moraga Energy and the proposed battery energy storage system at 358 Colebrook Road in Oakham, I would like to once again express my concerns. The residents of this town have made their position clear in more ways than one. They have fought tirelessly in opposition to this project. Many have spent their hard-earned money and devoted countless hours to opposing something that from the very beginning felt like a battle we were never truly given a fair chance to win. When Moraga first met with the butters, more than 150 Oakham residents attended.
Sorry, ma'am, I'm sorry to interrupt you, but could you slow down? The stenographer's having a hard time.
Oh, I apologize.
But just so you know, too, we do have her letter too that we can give you. Yeah. Go ahead, ma'am.
Thank you. When Moraga first met with the butters, more than 150 Oakham residents attended that meeting at the Berry Library. The fact that the meeting was not ever held at Oakham was to many an early indication that community concerns were not being adequately considered. Since that first meeting, residents have consistently voiced their opposition and raised legitimate questions about the project's impact to our town. I would also like to remind the board of the October 2025 Siting Board hearing in Oakham. This meeting was presented as a hybrid hearing, with the understanding that participants joining via Zoom would be able to provide testimony and comments. However, as you may recall, technical difficulties prevented your own audiovisual team from maintaining a stable connection, resulting in the first portion of the meeting not being properly recorded. More importantly, not a single participant was ultimately allowed to speak via Zoom. This raises serious concerns about the fairness of that hearing, a hearing that prevents a segment of the public from participating as promised and cannot reasonably be considered fully accessible or equitable. Furthermore, public comments were cut off at exactly 10 p.m., and there was no opportunity provided to reconvene and allow those who had not yet spoken to be heard. If the board's own technical infrastructure struggled to support a single public hearing, it is difficult to understand how residents can be expected to have confidence in the long-term remote monitoring and oversight of a highly complex battery energy storage facility. To many of us, the challenges experienced during that hearing highlighted the very concerns we have raised throughout this process regarding reliability, accountability, and public safety. The people of Oakham deserve to know that their voices were fully heard and fairly considered. Unfortunately, many residents continue to feel that this process fell short of that standard. Thank you very much.
Thank you. The Petrucci's? Thank you.
Good morning, members of the board.
Morning.
It's Piucci.
Thank you.
My name is Barbara Piucci, and I'm a resident of Oakham. I am speaking in opposition to exempting Oakham's bylaws so that an industrial scale lithium-ion battery facility can be built in our rural residential community. Over many months, Oakham went through a careful public access process to craft a battery energy storage bylaw. We did this deliberately and in good faith, with legal guidance and with full awareness of the Commonwealth's need for clean energy. Our bylaw does not reject battery storage outright. It draws a distinction between industrial, standalone grid-scale battery storage and battery storage that is integrated with clean energy generation. Standalone grid-scale battery energy storage is prohibited in Oakham but battery storage paired with clean energy generation is explicitly allowed in Oakham. That choice was not arbitrary. Oakham is zoned rural residential. This project would place a large industrial base next to homes within a very short walk to our elementary school, library, and town buildings, all in a town with limited emergency resources and highly sensitive environmental features. Our bylaw is the community's attempt to balance the real benefits of clean energy with the real public health, safety, and environmental risks of large lithium-ion battery storage facilities. Granting Maraga's petition would override our local judgment and allow an industrial facility that directly contradicts the bylaw that Oakham adopted after months of open, lawful deliberation. Approving this petition sends a message that rural towns' efforts to craft thoughtful, health protective bylaws, even ones that allow battery storage with clean energy generation, carry little weight when they conflict with a private for-profit developer's need for revenue generation. I ask that the Siting Board recognize that Oakham has already done what the state is asking municipalities to do, which is to plan for clean energy, consider the risks of large BESS facilities, and adopt reasonable, locally informed standards that allow energy storage in appropriate forms and locations. Let the private developers abide by the town's lawfully approved zoning bylaws the same way that all residents of Oakham need to do. Please deny the exemption of the town of Oakham's zoning bylaws. Thank you.
Hello, I'm Vincent Piucci. I have a very brief comment and a request. Throughout these proceedings, we've heard arguments for and against, seen figures and charts and technical filings, but one thing's been glaringly absent from this process: humanity. Oakham's not an abstraction. It's a real town with real people, people who work hard, many who are retired, but all of us share one basic expectation: that we can feel safe and at peace in our own homes. We chose to live in Oakham. We're willing to give up the amenities and conveniences of the city for the quiet solitude of country. Allowing this industrial facility will strip that away. The fact that this project even needs evacuation and shelter-in-place protocols for residents tells you everything you need to know. How can we feel safe in our homes knowing that at any time we may have to evacuate? I have one simple request. If after this hearing you're still inclined to approve this, before you do, come visit our town. See it for yourselves. Let us give you a tour of the town, meet some of our residents so you can see who they are and understand our concerns. Sit in one of the neighbors' backyards and listen to the quiet. Then imagine the constant hum of transformers, inverters, and over 1,000 fans. Walk the project site so you can understand our very real environmental concerns. See just how close the site is to our elementary school and town center. It's not the mile, as Mr. Benito said, it's more like 2,000 feet. Well, it's a short walk. Unless you do that, you can't fully understand the harm this will do to our town. So, you know, bring the humanity back into this decision. What harm could a visit do? Thank you.
Thank you.
We have a person
Susan.
whose name on Zoom is Suzanne. So I'm probably, that's probably Suzanne Shea.
Ms. Shea.
Yes, hello. Can you hear me okay?
Can.
Great, thank you. Thank you for taking my statement here. Oakham is a small town. We have a very high percentage of senior citizens. We barely balance our budget. We depend on mutual aid for fire, police, and public health to support our seniors. Every home is well water dependent. We are a quiet rural community. We don't have a grocery store or a pharmacy or a gas station. We are non-industrial, agriculturally zoned. I want to repeat that every home is well water dependent. Our citizens voted against standalone BESS. Our own governor signed our bylaw preventing standalone BESS. Our land was deemed critical for the Quabbin. Our town provided land for the Quabbin. Our forests, vernal pools, and groundwater interconnectivity should not be sacrificed for a standalone BESS. Our environment shouldn't support it. Quabbin water shouldn't support it. The science tells any reasonable person that 358 Colebrook is not a suitable site for a standalone BESS. What hasn't been mentioned is fire, air to ground chemical contamination. Are you willing to bet the Quabbin water in favor of this project? I cannot fathom that any reasonable person thinks this site is suitable, that this community is suitable. Cannot fathom it. Our citizens don't support it. Our town doesn't support it. We, as a town, have done everything right. We democratically voted. We passed a bylaw that the state approved. We have written, we have testified, we have submitted evidence-based reports showing the unsuitability of this site. Yet here we stand on the precipice of being forced to sacrifice our community for something we know in our hearts and minds is wrong for this community. This site is not environmentally suitable. Allowing democratically approved home rule to be overridden in favor of corporate interest is wrong. What these corporate interests have offered up is contrary to common sense for this site. This site is absurdly unsuitable. Famous philosopher Voltaire said, "Those who can make you believe absurdities can make you commit atrocities." Please don't commit this atrocity. I ask you to please vote no so a more suitable site can be found. Thank you.
Thank you. Yes, do we?
Just to make sure that was Susan.
Stays. So are there any public officials who would like to speak this morning? You could state your name.
Sure. Good morning, Madam Chair and members of the board. My name is Matthew Broderick. I am an elected official in town. I'm currently serving on the planning board. I'm also appointed on the Oakham BESS Committee, which was a subcommittee formed by the Board of Selectmen back this summer to help the town to coordinate its efforts around this project. I've lived in town for 34 years. I've served in multiple capacities in town government. I attended the site walk with the EFSB on October 16th, where for the first time in my entire life in Oakham, I actually got on the property of the old junkyard. Never been there before, never seen it before that day. We were given a limited guided tour, very prescribed walk on the property to where the batteries were going to be placed and where the 25-year-old forest sits. But even on that prescribed walk, there was very clear evidence of ongoing contaminants and pollution and commercial solid waste strewn about the property. I later found out after that walk that wasn't the half of it. And I was able to walk on the entire perimeter of the north boundary of the property, the eastern boundary of the property, and the southern boundary of the property, not trespassing, but from outside the boundary where there is in plain view multiple locations of legal dumping, landfilling, and automotive debris still in situ right now. Wasn't actually where I was going to go, but I'll just leave that there for now. Everyone else, I think, who has spoken has done a very good job of laying out the main central issues. I won't go over them again. But what I wanted to say is I do have a lot of concerns about this report. a lot of things. No way I can get into it in the 4 minutes I have. I would probably need about 4 hours to tell you everything that's wrong with this report. 508-981-9094. Call me, text me. I'm happy to talk to any of you individually about that. I can give you my email address. A lot of things wrong with this report. There's also a lot of things that are not in this report. And I'll just give you one example. And by the way, you're voting on a very, very big deal here, a very important thing that's going to affect a lot of people. I wouldn't want to be in your shoes right now if this is all you were given. I really wouldn't. For instance, does anyone know how much this project is going to cost? I don't think you do because it's not in here. This was something we specifically asked for in the evidentiary hearings, and we were denied that information. This public service corporation, so-called, feels that it can continue to withhold from the public the cost of the project. It still hasn't disclosed it. Now, quick cocktail napkin math from the public available information. 184 BESS units at about 2.6 million all in for delivery, equipment, installation, and service plan, about $2.6 million each. That's $478.4 million in just gear, battery gear. Medium voltage transformers, 46 of those at about, I'm going to estimate $24,000 each. Again, I'm estimating because they're not telling us. $1.1 million. Power transformer, 200 MVA, roughly between $3 and $6 million. The all-in price just on those numbers, and this is before a sound wall, which, by the way, can be in the tens of millions of dollars, which is why it doesn't encircle the entire facility in the design. All in $482 million. I'm just going to wrap up. On page 22 of this report, it actually says Morega stated it would own and operate the project with all capital, operating, and decommissioning costs borne by the company. And they say it repeatedly throughout this report, and they said it in testimony as well. They denied the town's claim that this was going to be passed on to the ratepayers. Does anyone seriously think that a venture capital company that's going to be investing hundreds of millions of dollars is giving that as a gift? Is that a donation to the Commonwealth? Of course it's going to be passed on to the ratepayers. And that's just Oakham. I mean, you've got Tewksbury coming in a couple of weeks. You had Medway. You have Everett. I mean, we're talking about billions of dollars in battery storage that the Commonwealth is indirectly committing the ratepayers to pay for. I say this because I'm not a financial expert. I say this because their main argument for setting aside the town's bylaws is that this is for the public welfare and the public convenience. This is not. This is going to cost us a pretty penny. And again, as everyone has already eloquently stated, we object to our local bylaws being set aside, but especially when that's the argument for it, that this is in the public welfare. One last thing on cost. 40% throttle speed, fine and dandy. That's just great. But you know what that also means? That also means 40% utilization. Does anyone think that spending $2.6 million on each battery unit and only using 40% of it makes any sense financially? I mean, that's the opposite of a discount, isn't it? I mean, that's what the ratepayers are going to be paying for, is very expensive equipment that is only going to be used at 40%. Now, I endorse the 40% because I don't want my town burning down. Okay, but I'm sorry, that's a different issue. I don't want my town to be blanketed in unbearable noise. But there is all kinds of problems. There's all kinds of things that are not in this report. And I'd be happy to take any questions, and I'd be happy to be contacted at a later time if any would like to hear the real story, what's been happening for the past 15 months between the town of Oakham and this company.
Sorry, Mr. Warbass?
Yes, thank you for allowing me a few moments to speak. My name is Philip Warbass. We have lived in Oakham, Mary and I, for 40 years. I'm a member of the planning board, and I just have a very little bit to say following that eloquent presentation by Matt Broderick. Just an example in real terms of what this noise issue is about. On a still day, we are 10 miles from a railroad, short line freight railroad that runs from Palmer to Barre, Mass. On a still day, we can hear the train whistle 4 times at each of the several grade crossings as it passes through Hardwick, New Braintree, on its way up to Barre. We've noticed that for 10 years. For years, we were trying to figure out where's that train whistle? Well, it's 10 miles away. The other real life example is Spencer Abbey has an Abbey bell that we can also hear on a quiet morning, quiet evening that's 5 miles away. The noise that one Tesla unit generates is equivalent to standing next to your lawnmower with no hearing protection. It's about 85 dB. What do those numbers mean? That's the example. 184 of those Tesla units logarithmically scale up to about 110 dB, and that's the equivalent of standing next to a runway 1,000 feet from a jet taking off. The other point I want to make is the issue about money in this fight. As Matt just stated, the Moraga group is backed by venture capital, millions and millions of dollars. In real terms, the town has spent what for our town is a huge amount of money already in the process of fighting this. And the interveners, especially working families, paying their attorneys to protect them to the greatest extent possible. The fear that they must be feeling every day, thinking about the likelihood of this being approved, and the fear of how they're ever going to pay back the legal costs of their intervener attorney protection. I don't know how much more I can express about this, but you should appeal to your own personal consciences when you make this decision. Thank you.
Thank you. I think we have one more, Sean Seeley, another public official.
Yep. Can you hear me?
We can. Thank you, Mr. Seeley.
Okay. Good afternoon. My name is Sean Seeley. I'm a member of the Oakham Conservation Commission. The Conservation Commission carries the responsibility of ensuring the protection of Oakham's wetland resources and the critical functions they provide. To carry out this important responsibility, we must be confident that all wetlands on the project site are accurately identified, delineated, and characterized so that appropriate avoidance, minimization, and mitigation measures can be implemented. Following our standard protocol, the Commission is thoroughly reviewing this project and its associated wetland resource area impacts to ensure compliance with the Massachusetts Wetlands Protection Act. Due to the complexity and scale of the proposed project, the Conservation Commission has unanimously voted to retain 2 qualified professionals to review potential impacts to wetlands and water resources. Please see written comments submitted to the docket file room on June 23rd for further details regarding their initial assessments. I also want to note that I have been communicating regularly with Mass DEP, and questions remain regarding the validity, extent, and resource area types covered by the Order of Resource Area Delineation issued by the Conservation Commission in 2024. These issues will be further addressed during the ongoing Notice of Intent process that is scheduled to be continued on Tuesday, July 7th. I understand that the Commonwealth's energy and environmental policy is intended to balance environmental, social, and economic factors, and that this is a complex and difficult task. However, water quality, biodiversity conservation, and ecosystem resilience must be prioritized in the siting of large-scale energy infrastructure. The Massachusetts energy infrastructure siting and permitting reforms that will be implemented next week will provide significantly greater consideration of forest removal and resulting carbon sequestration and storage, wetland vernal pool and hydrologic impacts, sensitive wildlife habitat, landscape scale ecological connectivity, and the need to avoid environmentally sensitive sites. Several key features of the site at 358 Coldbrook Road in Oakham would likely warrant denial under the site suitability analysis required by the policy reforms. The site is located in the headwaters of both the Quabog and Rare River watersheds, contains 3 certified vernal pools, and is ranked in the top 2% statewide for wetland connectivity by the UMass Conservation Assessment and Prioritization System. I believe that trust and coordination between local boards and state agencies is essential to the long-term strength and resilience of the Commonwealth, and I ask for your continued support in our shared goal of protecting the wetland resources that provide vital ecosystem services to the region. Thank you for the opportunity to provide comments and for the board's consideration.
Are there any other elected officials? Okay, seeing none. We're in a bind on time. It's noon now, and I want to give the board time to deliberate. So I think we're going to move on now to start the deliberation. Oh, hold on. Nope. We have finished the list of people who signed up to speak here. So we're going to move on to our deliberations, and we'll start that by putting a motion on the table. So do I have a motion to adopt the tentative decision?
So moved.
Second?
Second.
Okay. So we are now going to leave that motion on the floor, and that will give us time to now talk about the further discussion. We will first consider amendments to the tentative decision proposed by the staff, and then we'll consider any additional amendments from board members. So let's start with the staff amendment sheet. We were provided with a staff amendment sheet last night. I think everybody has had an opportunity to review it. Is there any discussion on any of the particular items or any questions about the items on the staff amendment sheet?
Madam Chair, I have a question.
Yes.
Sorry,
go ahead.
Thank you. On condition CC, which relates to the emergency response plan, there is language here that refers to consultation with the Massachusetts Clean Energy Center. I recall that the CEC previously ran a storage education program, or they at least funded a storage education program, storage training program, I should say. But I don't think that program continues. And I'm wondering if the CEC is the right reference here, or if we could replace it. So I'll start by asking kind of where that we pulled that from. I do have an alternative.
I had the same question as well.
We also happen to sit on the CEC board, so we're familiar with their work.
So,
Mr. Goodyear.
yeah, Madam Chair. So I, in preparation for serving on this board, have been trying to understand energy storage, battery storage, and I've had discussions with a whole bunch of different people, and they suggested CEC, and I can go through my book to figure it was, but I had a briefing, and you all have, CEC has webinars that they use for public safety officials around battery storage. that are NFP, National Fire Protection related, and they offered those as a resource. I don't know, I mean, the commissioner would know well if they're still doing the trainings, but the webinars exist and they're a good resource, and it was a great education for me to be helpful to understand the nature of what was offered. So that was one of the discussions that I had with.
Thank you. That's
staff.
helpful. I would suggest that those, as we sort of picked out a little bit today, because of the dynamic nature of this industry, we want to make sure that when we are providing resources to the town, we're providing the most up-to-date resources. I would suggest that we change in this language, rather than saying in consultation with the Massachusetts Clean Energy Center, I will volunteer as tribute, but we change it to the Massachusetts Department of Energy Resources. We are currently are deciding on final grantees for emergency training for BESS, and we have intentions to create an ongoing training program. So I think we've stepped into that role that it was started by the CEC, and are trying to make sure that we are providing up-to-date and ongoing information to the public. So I think it's a great idea to have somebody else helping contribute ideas and maybe being a third party to help make sure this is done right. I would just suggest that we change it from CEC to DOER.
Any other discussion about these proposed changes?
Thank you to staff who digested an incredible amount of information and feedback and put together these amendments very thoughtfully and very efficiently. In particular, from the environmental standpoint, I think condition W is very helpful, particularly to respond to a concern which the town raised and I agreed with, about when the LSP would be retained and helping to make sure that the site is brought back to compliance with the Massachusetts contingency plan. So this new condition W addresses that concern, makes it very clear the LSP is to be retained prior to any site alterations, and retained throughout the project construction. So I don't have any changes to that, but I did want to acknowledge that because that was something that we would have proposed otherwise. Condition X similarly is very strong and addressed some concerns that DEP initially had. I would propose, in response to some of the concerns that have been raised about the environmental assessment, I do again appreciate the company confirming on the record today that it understands its obligations under the MCP, that it will remove debris on the entire almost 43-acre project site. I would propose, in addition to condition X, that the company retain qualified LSP to provide LSP peer review to the Oakham Conservation Commission. I understand these are complicated issues. We appreciate the work of Concoms across the Commonwealth and appreciate that they are often doing this on a volunteer basis. So I do think it would be helpful for them to have the technical support of an LSP funded by the company to make sure that they have the ability to really thoroughly review any reports and actions that are certified by the company's LSP.
I too had the same thought and was appreciative of these additional amendments, specifically this one with condition W and X. But I agree with that. So where would you propose to do that? Would you put it with one of these motions, one of these amendments?
I think just in addition to the end of condition X is probably most logical. If staff have a different recommendation, I'm happy to hear that.
That looks fine.
We can add a sentence to the end of condition X, indicating that the company shall retain a qualified LSP um, uh, for the town to conduct peer review of the environmental assessment.
Maybe add the town gets to select. You can put in the right language, but the town gets to select who that LSP is if they want to.
I think that is already in
Implied.
condition W.
Okay, got it.
Perhaps this sentence should go at the end of condition W, which talks about selection of the LSP.
That made sense.
One additional comment related to the new condition RR, which relates to testing of private water supply wells within 1/2 mile of the project site. Based on some of the testimony we heard today and concerns that have been expressed previously about properties that, are served by wells that are very close to that 1/2 mile, but beyond that threshold, I would propose extending that to within 1 mile of the project site.
One question without a specific line edit. One of the concepts that came up today is were the project to move forward, that the town and the company would work in good faith with one another to achieve the execution of the conditions to the project. And I don't know exactly where that would be reflected in the conditions, but I think that is a sort of an overarching condition where the project, if the project is to go forward.
It sounds like you're proposing that as an additional condition. Would that be fair to say?
I think it's, I defer to the sort of staff on where that goes, but I think it is a condition for going forward that there is across the board, sort of an addition across the board that both parties engage in good faith cooperation during construction and operation.
Mr. Guccio.
Yeah, I had a couple of things. I agree with that comment 100%. I mean, there are a number of things that there was ambiguity in around the decommissioning, around potential investment in fire capacity or equipment or any of that, and it seemed that the testimony suggested that that would need to be worked out with the town. So I'm worried that if this moves forward, the ambiguity would allow a loophole that doesn't allow the town to have a little bit of leverage to ensure that they have satisfactory conditions. So that, and those are just two of the items that, assuming if this moved forward, that that there would be a little bit more clarity or leverage to negotiate a finer point on some of those things. I don't know that we have the authority to prescribe certain things, but those are some things that I think would be beneficial.
I mean, there are many conditions so far, right, that say that the company shall work with the town to do X, right?
Yeah.
So I'm not quite sure what we do about how would one make that a stronger statement?
That was my question to the board.
Yeah.
I don't know. And maybe you can ponder it, but I did have one additional one unless you wanted to take that on.
You're looking at me, right?
I was.
Okay. So I'll just say the amendment, the condition that Chair McDermott proposed, I would envision being an additional condition, and it's easily incorporated into the decision, and it seems like a very reasonable condition. Mr. Good, oh yes. I think the concern you raised, Mr. Goodrow, is best addressed by looking at a particular condition that requires the company to consult with the town. That terminology is frequently used, and we could just dive into one particular condition and examine your concerns in that regard, because I agree with you that the obligation to consult is really an obligation to invite the town to provide feedback input. It's an obligation for the company to consider that input and to reasonably implement that input to the extent practicable. It doesn't really give the town leverage. It doesn't give the town the ability to stop the company from proceeding. So I perhaps we could pick one condition and examine your concerns in the context of that condition. So let me just, I could, do you have a particular condition, or
I just mentioned to, I just mentioned to, obviously the town is in opposition, but should it go through, and if a community benefit agreement was negotiated, what would they say in terms of improving fire equipment capacity, whatever the case may be? You know what I'm saying?
Yeah, if I could just figure out which condition it is, and we look at the actual text.
I think the condition that the fire equipment issue relates to is the new condition PP, which would go in page 146. It's on the amendment sheet.
Well, so this is a condition that is different. In my opinion, this does give the town more authority than a condition that simply says that the company must consult with the town. This gives this new condition PP directs the company to work with the Oakham Fire Department to identify additional tools or resources and to provide funding to the town to address those items. So, as agreed, there is an implied standard of reasonableness that both parties must engage in. So it doesn't give the town unlimited ability to say any item that the company would have to provide funding for any item. But in this case, it gives the town some leverage because of the implied standard of reasonableness. If they're not able to agree, they can come back to the board for an interpretation. But this condition does give the town grounds for insisting that the company provide funding for reasonable equipment.
Can I ask one more question? Unless it's on that topic.
It's directly related to that, yeah, if I may.
I'll yield.
Thank you. Rather than implying reasonableness, do we want to specify reasonableness? I mean, I'm just always hesitant to intrude too far into the negotiations between a project proponent and a municipality. I prefer to give the municipality the freedom to identify what it really wants or needs, and think that cities and towns know that better than we do sitting up here. So I think this is about as far as I would go in terms of prescribing something related to a community benefits agreement. But if we are to do this, because of, concerns that have been raised, I do think it would be wise to say something like provide sufficient funding to the town, reasonable. We could put the word reasonable in there somewhere, but just, to make clear that the sentiment that you, Mr. Presiding Officer, just raised, that this isn't a blank check. It's to be reasonable in these negotiations and reasonably fund what could be needed if there's a worst case scenario type of situation.
Commissioner Heupel, I agree with you that adding the word, say, adequate funding would be appropriate because we're not just asking them to provide funding. It needs to be adequate to the tools or resources that the town has reasonably identified as being necessary.
I had one more if I could go back. And so noise was a persistent concern that we heard in the testimony. And this is something that I hadn't thought of before this, but in industrial settings, continuous noise monitors are prevalent in industrial settings. And so there was a lot of talk about testing noise levels baseline and testing noise levels subsequent. But, you know, I mean, I represent the Executive Office of Economic Development here, but I spent 22 years elected in my own hometown. So I understand neighborhood concerns in a real way. And you might get the phone call and then the noise meter goes out there and it's after the moment happens. And that's the value of continuous monitoring of noise meters. So I am asking if the board has the authority to prescribe that kind of continuous noise monitoring takes place at certain locations around the perimeter of the property and that data be collected and stored, or maybe even transmitted and publicly accessible so that all parties can go back to a moment and it's not he said, she said on whether or not there was a violation of a noise issue at any given moment and identifies, you know, specific locations around the perimeter that might be mutually agreed upon that would be valuable. So I'm asking that of the staff, whether or not that is something within our purview that we could ask.
Well, I think it's within your purview if it's reasonable. And I think it would be useful to hear from the analysts and perhaps the company regarding the reasonableness of constant sound monitoring. Is that something our analysts can address?
I think currently, the siting staff will have not developed like a separate policy or implementation of how enforcement of noise apart from how our interpretation of the Mass DEP noise policy. And currently our understanding is that they don't do continuous noise monitoring. So that's our understanding when developing the tentative decision. So, I mean, if this is suggest, then it will be quite a novel thing. I'm not saying that that's not a good idea, but that's just not something that we have developed in the TD.
And if I may, I'll just add some factual information. So the testing that they're planning to do is based at what is considered a quiet time of day. I believe, is it 2 a.m. in the morning? And they are planning to do the testing at the full 40% throttle. So what they're trying to do is do the testing when the sound is the highest that it will be. The sound will fluctuate, but it has kind of a maximum amount. So I personally don't see constant sound monitoring as being useful because the sound monitoring they plan to do is at the highest level.
The question, I guess, is what's the downside? And I don't know what the expense is to buy a piece of equipment, whether it's portable or permanent, and what it costs to operate it, and collect the data or transmit the data.
So sorry, could you just repeat that again? I had a couple of voices going on.
I was saying, I don't fully understand what the downside is of it. I think it would certainly probably go a long way with the neighbors and the town, and it would demonstrate good faith, and it would show that this is the data collected, this is, timestamp because they have their technologies existed for 20 years to collect real-time data around noise levels or air quality or whatever the case may be, and transmit that data to a place that it's stored so that everybody can see what the data says. And then a second change would be if there's a violation of it, what would the condition be that we would include should a violation occur? So those are two separate questions.
So I'd like to, thank you, Mr. Guccio. I'd like to hear from the company about this, but also would like to hear from the town. I have to admit, I wouldn't want monitors 100% in my neighborhood, like doing noise monitoring. Like I wouldn't want that. So I don't want to presume that that would be something that people would necessarily want. So let's listen to the town for the company first.
Yes, thank you for that question. With regard to the consistent, constant 24/7 monitoring of noise in the industrial area, I believe that those are typically associated with OSHA and worker safety requirements, not necessarily meeting the Mass DEP noise guidance. I think we think as the conditions written is appropriate in following the precedent that's been set before. That being said, of course, we want to acknowledge that this is a significant concern and perhaps doing something more than just once, for example, maybe in the first 3 years annually or something like that, maybe more appropriately. I would also like to identify the fact that many of these ambient noise sensitive areas are off property. So we would then need to require some sort of easement or access to private property or the side of the road for some folks. And lastly, as you've heard from folks here in the room, the exact location of where those monitoring areas are placed is up for dispute, and I would anticipate that would continue. So for those reasons, I would respectfully request that we keep the condition as is, or if modified, put some sort of annual requirement for the first 3 to 5 years.
We hear from the town, please.
Yes, thank you. I think the suggestion is a viable one, and I appreciate the suggestion being made by the board member. I would urge that we do add a condition along this line. If it's something that can be done with practicality, the collection of data does avoid a lot of disputes because it avoids that type of thing, like somebody has a problem at 9 o'clock, and then by the time somebody comes out to investigate it, the noise is over. The collection of data and then a place to look at it can identify trends, and it can show if overall, you're in compliance. So what I would recommend, definitely, we can't work out the language of it today, and it sounds like staff, doesn't typically do that type of thing. I mean, what I would recommend is some type of condition saying that the company shall collaborate with the town and qualified experts on a post operation monitoring, sound monitoring protocol, collection of data, seek to reach agreement on it. And if a protocol can be reached with what the equipment is, where it's located, and then come back to the siting board if there's a dispute over it. But I think the suggestion would be very helpful for what's going on after.
Yeah, I do like the idea of having the town and the company talk about what would be a reasonable protocol, and not sort of making that snap judgment here today without having everyone have time to think about that, and what it would mean for different people to have monitors, et cetera. Mr. Ferry, do you have a question?
Excuse me. Thank you. I know we didn't get a chance to talk about noise, but one of the things we were going to say, I think makes this suggestion quite interesting. And let me say first, in a project that costs between I think we heard today, closer to half $500 million, it's certainly probably at least $250 million, a couple $1,000s for an instantaneous noise modeling sensor, I don't think would be very expensive in the whole scheme of things. One of the things that came out during the hearing, and that's why I think the data argument makes some sense, is that one of the issues was that the noise modeling was largely Tesla's model noise. And the question was asked, Do you know that these batteries degrade over time? They get hot spots, they get much hotter, and the fans are going to have to run more than 40% full throttle if there are hot spots in the batteries. And the company basically conceded that. And we said, have you been able to model what happens in year 2, 3, and 4 of the batteries? And they said, no, we only have Tesla's information here. And the question came up, well, Tesla's probably giving you a brand new battery, but have you seen the data that in years 2, 3, and 4, there's something called a J curve where it spins up and can be a 50% increase in hotness in the battery, which means you're going to need to run the batteries potentially at more than 40% throttle on the fans to cool them. I know that's not proposed, but the question is, if it happens, it would be nice to pick that up with noise. The other issue to have something that would be around the clock and it would be small cost is just because you monitor this at 2 o'clock does not mean that's the time when the company is charging the batteries. Typically, it would be charged in the off-peak hours between 11 and perhaps 6 a.m., but you're not necessarily going to pick that up. If you had right on the property line, again, there are 6 residences on the property line just on one side that they share the property line. If on 2 or 3 or 4 of those, you actually measure that, then that data would be there. If it proved not to be useful after a couple of years, you could discontinue it by mutual agreement. But I think that means a lot, and I think that would restore at almost no cost the ability of both the board and all the parties to see what's actually happening.
Go ahead.
I believe that condition V does address some of these issues.
Condition
Condition V.
V.
V
As
is in
in
Victor.
Victor.
The company shall consult with the town on the selection of the contractor conducting sound testing or sound modeling with 3 prospective contractors. So I think that addresses one of the things that Mr. Pucci was saying. I think in terms of monitoring 24/7 for years, I'm wondering if there's a possibility of, if there's a complaint by somebody, the testing can be done then. It can be done, I believe the testing is done over 8 days. So it's not just coming in and determining whether or not a sound might have happened at 4 o'clock in the afternoon and you never hear from it again. This would come in, and that may be something that can be done in addition to condition V, where if there's a complaint by somebody.
Ms. Evans?
I just want to note there's that possibility. I would note that the proposal by the town for to have the town and the company work together on a sound monitoring protocol. We've included that kind of language in the past in decisions of the siting board to where we don't have specifics of a protocol, but we encourage or require the parties to go back and work out the protocol between them. And I suggest that condition V mentioned by Mr. Kaplan would be a good place to put such language. Matter of fact, I could propose some language if you would like.
The concept is to augment condition V to reflect the sort of direction to have the company and the town sort of put together a sound monitoring protocol over the first 5 years of the project's existence.
Or let them figure out the amount of time just to have them work together on a protocol and file it with us.
I think the idea is this sentiment of the board that, and I'm not speaking for everybody, but I think the sentiment of the board is that the one testing after construction, it might not be adequate and that we would be expecting additional monitoring.
Would you like me to propose a sentence just to
Yes, please.
modify that as before we go on to the next subject?
That would be helpful.
Okay, so on the amendment sheet, we have a revised condition V as in Victor. I would suggest after the sentence that reads, the siting board further directs the company to consult with the town on sound testing and any future sound modeling, including soliciting input on noise monitoring locations. I would add, In addition, the siting board directs the town and company to collaborate on a sound monitoring protocol and file such protocol with the siting board. I didn't, we might want to include a number of days after the project is operational, but I'm not sure what would be an appropriate number of days to produce that.
I mean, I wonder whether it makes sense to have that conversation after the first test. I don't know.
Sorry, respectfully, I mean, that doesn't address concerns raised by the former elected official.
Well, I think he could speak for himself, sir.
I know, but I just heard him and
Okay.
what he said made sense.
Okay, if he has an issue, he'll raise it.
May I speak to it? That the sentence that was suggested does not cover that. He was suggesting a protocol that you can collect data over a period of time. It's not one testing.
I think the question is whether that is what people really want. And I think the idea was to give the town and the company an opportunity to talk about what kind of sound monitoring protocol you want. Mr. Guccio, I understand. Maybe you want to speak.
No, I think the chair is suggesting that it's going to be deferential to the town and the company to negotiate that subsequently, and the language is broad enough so that you can raise all of those issues. Is that fair to say, Madam Chair?
That's what I was trying to say.
Yep.
Well, I apologize. It sounded like what was suggested on the sentence was just a protocol for an initial testing following operation. And what we were thinking about.
No, what I guess what I was,
data.
what I was trying to say was that perhaps having that conversation would be better after we had more knowledge after that first test. That's the only thing I was saying. But I don't know. I
apologize. I'm just, it's completely unworkable because if the company then decides that they're not going to do long-term monitoring, we have no relief. Where does the town go? The town can't go back to the siting board. The condition said what it said. That was why I was suggesting earlier, some type of condition now that the company shall work with the town and qualified experts to come up with a proposed long-term monitoring plan after operation. That's what I'm talking about. I don't want to just be left with a meaningless condition that we can't enforce.
Would you mind reading the proposed language again?
Sure. I think
Thank you.
it sounds like maybe the timing of the protocol, developing the protocol might be the issue here.
I think what he's raising is that it wouldn't necessarily be a long-term, that we're not putting a time frame around it.
Okay. The sentence I suggested, which could be modified,
Yes.
is that the siting board directs the town and the company to collaborate on a sound monitoring protocol and file that protocol with the siting board. But I did not indicate a time frame for that, and I'm left it open because I wasn't sure what the appropriate time frame would be.
Ms. Evans, can I just suggest maybe inserting a phrase somewhere in your proposed language, including consideration of long-term continuous sound monitoring? So it's clear that that's part of the discussion that ensues between the company and the town.
I think I might have concern with continuous. Not that we don't want long-term monitoring. That word continuous, I have concerns about 24/7 monitoring and public privacy for the nearby residents. But I think we agree with town council proposing that it's not just one time. That's not what we're looking for. So ongoing, yes, that feels better than continuous. Thank you, Chair.
And the word consideration also gets to that point. You didn't catch me? Sorry. And the inclusion of the word continuous also gets to that point, I think.
No, we want to take.
No, I don't.
We're taking swap continuous for ongoing.
I think she initially said the word consideration.
And,
gets to that
and
point.
consideration of ongoing long-term sound monitoring. Is that what you're looking for?
I feel comfortable with that.
Yes.
I did hear, I think ongoing is better. I did hear, Mr. Chairman, you're not the chair of this hearing, but you're the chair of other hearings, mention 5 years. We can, obviously, the point is to, have some collaboration between the town and residents and the company on this. But I don't know if it behooves any of us to have that left wide open. Like, are we looking for ongoing monitoring until the end of time, until decommissioning? I don't think so. So what gives us a data set that gives us the baseline, right? Gives us, some check-in points, not just one, but into the future about actual operational noise, sound, I should say, but doesn't just have, I worry that if this is unlimited, we generate so much data that data is rendered meaningless. If you have to look at a dashboard every day and you're getting readings from all these places and you have decades and decades of data, is that actually worthwhile and beneficial?
Would it be useful to include the phrase "as long as reasonably necessary"?
Who determines that, I guess, is what I'm struggling with.
Well, the company and the town together, I would think, determine that. But at least it gives them just a guideline that that's something that they have to determine. How long do they think it's reasonably necessary to continue the sound monitoring?
I think I'd rather have a time.
I mean, could we do an initial, suggestion of a 3 to 5 year time frame? And then, I mean, certainly there is recourse, right? If something has gone wrong and the fans are too loud, you can call your local, we can call the town, you can call EP, so not to offer ourselves up, but maybe a 3 to 5 year suggestion as part of those discussions between the town and the company, and a provision that we revisit additional monitoring if there is, an influx of complaints. You will all find a more elegant way to say that. But if there's an ongoing issue after 5 years, turn the monitors back on, get some new data, but not just have them running until the end of time.
Let's do 3 to 5 years.
With a reopener for issues or no?
Sure.
You want 3 or 5?
3, 2, 5.
3, 2, 5.
So I think that gives folks the flexibility to talk about it, right? But we could say, discuss, we're directing the town and the company to discuss or for a reasonable time frame, i.e. or e.g. 3 to 5 years.
Would you like me to read it back where we are right now?
Thank you, yes.
Let me know whether or not I've caught it. So right now, I have an addition to condition V that's going to appear before the last sentence in condition V that's on the amendment sheet that reads as follows. The siting board directs the company and town to collaborate on a sound monitoring protocol and consideration of ongoing long-term sound monitoring for 3 to 5 years and file that with the siting board. Not sure I caught what you were looking for.
I think you probably need to take out the maybe just replace long-term with a 3 to 5 year plan.
So in consideration of ongoing sound monitoring for 3 to 5 years. Can you help me out?
Wish I could.
I'm going to raise my hand from now on. Madam Chair, I
Thank you.
apologize.
could we have funding? The sound experts are very expensive. There's a few of them and they're very expensive. And I'd like to have a qualified expert to be able to collaborate with the company. Because they have one. We had an expert witness in the trial and they're very cost prohibitive. So I would request reasonable funding for the town's expert to provide the input for the collaboration.
In my experience, the expense associated with the sound experts is typically associated with the modeling efforts, more so than like the raw data of a sound monitor.
Where I would need an expert would be to suggest something that's practical. Like what are the devices that we're talking about? Where would they be located? What happens if there's heavy snowfall? You know, I don't know anything about this, but I'm sure an expert.
Can you agree on a single monitor, a single person to help you both?
I think that's what's in condition V.
That's what's in condition V, and the company would pay for that.
Madam Chair, the one thing I didn't hear added to that last condition change was that if in the event that there were noises that seemed louder, that there'd be, after the period of 3 to 5 years, that there'd be some recourse. So let's say the parts wear out and it becomes louder. I think that's what I heard town council mentioning earlier. What's the recourse?
Yes, I was thinking that could be part of the protocol.
Okay.
If I may just have a moment, I just wanted to look at the on a preferred contractor candidate. Is that what we're talking about?
Can you slow down just a bit? I think
Okay, thank you.
Okay.
The new condition V, so the language in the amendment sheet.
Ms. Evans, do you feel like you have what you need there?
Sure.
That's correct.
Yes.
On the new sheet. Yeah. Okay. Other issues with respect to the staff's proposed amendments, and then we'll move on to additional amendments.
May I suggest that before the board votes on the staff amendment sheet, I walk through what I believe are the 6 changes to the amendment sheet to make sure that it's clear as to what we are voting on.
Yes, let me just, online, do you have any comments on the amendment sheet? Just want to make sure everybody's getting a chance to respond. Okay. Okay, go ahead, Ms. Evans.
Let's hope I have it. I believe we agreed to 6 changes to the staff amendment sheet. First off, in condition CC, we are changing the term Massachusetts Clean Energy Center to Massachusetts DOER. In condition W, excuse me. We were asked to change that such that the company make it clear that the company is to engage in a license site professional that engage includes the company actually retains the licensed site professional. Thirdly, in condition RR, we are changing the well water testing to within 1 mile from a half mile. We are inserting an additional condition. This would be new condition SS, which states the siting board directs the town and company to work in good faith to implement the conditions in this decision. S is in Sam. S is in Sam. That's number 4. Number 5 is condition PP. The new condition PP would now read, the siting board directs the company to work with the Oakham Fire Department to identify any additional tools or resources that would be necessary to address a best fire and to provide adequate funding to the town to address these items as agreed. That was number 5. And number 6 is back to what we were just discussing, and I actually adjusted it just a little bit more. So this is an additional sentence to be added into condition V as in Victor. And the sentence I would suggest reads as follows. The siting board directs the company and town to collaborate on a sound monitoring protocol, considering ongoing sound monitoring for 3 to 5 years. And I would also add, and consider recourse for responsive action in the event of excessive noise. And that's what I have.
Mr. Kaplan, do you want to say something?
I just wanted to wonder if there's one thing that can be added to condition X. Under number 2, comply with any, when we say non-appealable.
You'll note that that portion of condition X says final.
I know.
And that was in understanding that there's some back and forth on regulatory action right now. That was the intent of the word final.
I don't think there's any harm personally, and as the person who would probably be fighting with you over that, in adding final, comma, non-appealable. We can wait until everything's resolved before requiring compliance. Thank you for that list, Ms. Evans. That was a very helpful recap. I thought we had also talked about adding in condition X the requirement to provide LSP peer review for the Oakham Conservation Commission related to environmental assessment and remediation.
Yes.
Thank you.
I missed that. Thank you. Thank you. Just to note, we decided to move that to condition W because that's what discusses the LSP selection process. So we did add one more sentence that I missed. The company shall retain a qualified LSP for the town for peer review of the town assessment. Is that the correct term? For the company's assessment, thank you. Peer review for the company's assessment.
I'm just looking at to make sure that we're referencing the right assessment in that different condition. Perhaps we just say to provide LSP peer review to the town related to environmental assessment and remediation.
Thank you.
Yeah, sorry, just to clarify, we don't need 6 recommendations of an LSP and 2 LSPs, right? It's 3 recommendations to choose 1 LSP. Okay, I wish I could say that more clearly. I believe, I just want to clarify, I just want to make sure that we're not hiring 2 LSPs and giving the town 6 names of LSPs. Is W and X related?
That's a good question, actually. So was the intent, this is a question for staff, was the intent of condition W to require the proffering of 3 prospective candidates? So the company has an LSP now, correct? Was the intent of condition W to require the company essentially to potentially hire a new LSP? So to put forth 3 recommendations to the town provides a recommendation back on the company's LSP?
Thank you, Commissioner Heibel. I think the intent of condition W was that the company and town use the same LSP, but collaboratively. But if the intent right now is to have a pre-review as a LSP apart from the company's own LSP, then I think that becomes redundant. So I think the board can choose which one is the more proper approach. So if we are going to ask the company to retain our LSP, then they don't have to provide 3 for the town to choose, because the town would choose another one of their own.
Would the company or town or both like to respond to that?
Yes, thank you. So currently the company has SWCA just for consistency purposes as under retainer as that LSP. However, under condition W, we were interpreting that we would provide SWC as well as 2 other LSPs to the town, work with them to select whichever one we all agree on to move forward with this condition.
So if faced with a choice of doing that or keeping SWCA and then hiring a new LSP to consult with the town, what would be the company's preference?
The company's preference would be to provide SWCA as well as 2 others and agree with the town on moving forward with 1 LSP.
Okay.
I'm fine with that, but are we still providing for peer review? Because that would be 2. In other words, you get an agreed LSP that the company is using, and then we get funded peer review.
What I'm hearing from staff, because we were thinking about the interplay, right, between these 2 conditions and this potential addition, is that the goal of having the 3 proffered candidates is that there's agreement on 1 LSP, the town, the company, everyone uses that 1 LSP because everyone's had a chance to weigh in. My question was whether folks prefer that, or folks prefer the company can use whoever it wants, but the company also has to provide a new LSP for the town to consult with related to the environmental assessment and remediation.
Right. I would prefer the latter. They can select whoever they want, but we get to choose an LSP peer reviewer, and the only conditions would be comment to any land use permitting matter would be qualified and no conflict of interest. And whoever that is that we select, they have to fund. That would be my suggestion.
Yeah, I think the L and LSP satisfies your first requirement, right? They have to be licensed, certainly.
I'm just referring to the typical 53G language. Qualified, no conflict of interest. I would have a few suggestions for them on the LSP that I would be surprised if they had a problem with.
But you're saying you'd rather not be able to provide suggestions, I thought, and you'd rather have your own.
I would rather have my own. That's what I'm saying, is they can select who they want, and we get to select who we want, subject to they're qualified and they have no conflict of interest, and they have to fund it. Because I don't want to be locked into one LSP that is essentially working for the company only. I want an independent peer reviewer on behalf of the town.
Yeah. And I mean, we certify them, we license them. They are independent. They are subject to their own licensure and professional obligations. So they can't, like, any LSP worth their salt. We have a board that they're brought in front of if they are not doing the right thing. So it's not like you can buy a result from an LSP, just to reassure folks. And DEP does audit LSP work to make sure that it is consistent with our standards.
You did it in South Coast Wind. You
Yes.
and I apologize. I called you commissioner, secretary.
No, you gave me a promotion. You don't have to apologize.
Anytime you want.
We did it in South Coast.
I decline.
Wind. We did it in South Coast Wind, and there was no issue at all. That with the LSP funded by the company.
So it seems like that option is the path forward on this particular condition.
So it sounds as if on condition W, we're taking out the last sentence, right? About the consultation, and we're adding in the sentence about the company retaining a qualified LSP for peer review of the company's remediation, evaluation, and assessment. Is that what you would like?
The company shall fund a
Qualified LSP.
a qualified peer reviewer LSP to provide LSP peer review for the town related to environmental assessment and remediation. That was the language earlier. I said
That's
it
correct.
best.
Thank you. But removing the last sentence in W as it appears on the amendment sheet right now.
Correct.
Correct.
Okay. Shall we vote on the changes to the amendment sheet? Do we already have a motion on the table for that, or do we need to do that? Anybody?
You need a motion.
We do not, and I will so move.
Second.
Chair McDermott,
Yes.
Commissioner Mahoney,
Yes.
Commissioner Heipel,
Aye.
Commissioner O'Shea,
Aye.
Director Guttrow, Mr. Callahan,
Yes.
Mayor Cahill,
Yes.
Mr. Bonfilio,
Yes.
and Secretary Tepper.
Yes.
Motion carries.
Okay, so now we're going to think about individual amendments, if we have any more, and then we're going to talk about the whole thing. So do we have any additional amendments that we want to add to the decision?
I'm sorry, I'm the way you worded your motion, you voted on the changes to the amendment sheet. I think you should vote on adopting the amendment sheet as changed. So it includes everything else that's on the amendment sheet that's not changed.
I will restate the motion to adopt the staff recommended amendments as further amendment by discussion.
Sorry about that. Thank you.
Second.
Do it again.
Here we go. Chair McDermott.
Yes.
Commissioner Mahoney.
Yes.
Commissioner Heipel.
Aye.
Commissioner O'Shea.
Aye.
Director Guttrow. Mr. Callahan.
Yes.
Yes, yes.
Mayor
Microphone's
Cahill.
Yes.
Mr. Bonfilio. Sorry, you're muted.
Sorry. Yes.
And Secretary Tepper.
Yes.
Motion still carries.
Okay, so additional amendment proposals. Mr. O'Shea?
I'd like to find a way to ensure that there's some mitigation for clearing of the 6 acres of forest.
Yeah, I'm there too.
And, you know, I know that it said that it would not have adverse impacts on wildlife. However, 25-year-old forests are actually one of the unique and relatively uncommon types of forests in Massachusetts that provide habitat for species of greatest conservation need in the state. And they're part of our state wildlife action plan. So I would actually suggest that the company be required to provide some mitigation for the clearing of these forests.
And I just be clear, so that would be in addition to the 1 acre that we're proposing now.
Exactly.
And do you have any particular suggestion? Are you suggesting like off-site?
I'm suggesting off-site mitigation within the town of Oakham for the protection of forests.
A particular size?
Of at least a 1-to-1 replacement.
So 4 acres, because they got the one that they're keeping.
Yep.
And how would they go about doing that, just to make sure that we're clear, we understand what that means?
Well, I think that it's possible to provide, you know, mitigation in a form of a trust, of which could be used for the acquisition of protection of forests somewhere in the town of Oakham. Then we can define what that trust is and so forth. We have a trust at the Department of Fish and Game for such purposes, but happy to be flexible on that.
Would it also work if they used something like Mass Audubon or?
Absolutely. Local Conservation Trust, Mass Audubon, or similar organization.
Would DCR work?
I think DCR works as well.
Just thinking, because there's
Yeah, they have land nearby.
a fair amount of land nearby. So are you suggesting that there would be some, I just want to make sure I understand. Are you suggesting that there would be some conservation restriction on existing forest? Or you're suggesting
I'm
that
suggesting a replacement for the loss of the 5.9 acres of forest
new
with new
planting trees?
probably the protection from existing undeveloped and potentially developable land somewhere else off-site. And so, yeah.
Okay, I understand now. I just want to make sure I understood.
Yeah, having said that, the other land on the site isn't restricted. That's a different question. The other land that's not being proposed for development isn't restricted. And that's a different conversation and possibility.
So are you saying another option would be for them to put a restriction on the
current area right now that is not being proposed for development? That is an option.
Okay.
I believe that's condition MM.
MM. And an old MM.
MM's a new condition toward
It's a
the
new-
end of the amendment
Oh.
sheet. A new condition toward the end of the amendment sheet.
Yeah. So yeah, I wasn't aware of condition MM, but my original intention was to create a new condition that mitigated for the loss of that 5.9 acre forest offsite.
Oh, this right here.
Okay.
1 acre conservation.
So I just want to clarify, because I think we just jumped into 2 different ideas. Commissioner, your first suggestion is that the company do a 1-for-1 replacement of whatever acreage they lose on the site to build the project somewhere else in town. So
Correct.
acquire, conserve through a trust, Audubon,
It could be an easement on another property, it could be acquisition on another property, but that's separate from the idea that was additionally raised about conservation restriction on that particular site that they own currently today. That's a separate, my motion was to conserve one-to-one replacement through acquisition of either fee or conservation restriction in town.
Okay. So that would be one-to-one replacement separate from MM. And then we can talk about what MM really means.
I think he was thinking not 5 acres, but 4.
Well, 4, it did minus the 1 acre, correct. But I think this is where the acres get a little iffy. I saw in the tentative decision, 5.9 minus the 1. So.
But then I think the company stated today that the project has changed such that it's going to be
only
5.
5. Okay. So then we're talking 4 acres then. Okay.
Does the company have something they'd like to say about that?
Yeah, I think this is reasonable. We would request that it would just be, rather than 1 acre or 5 acres or 5.9 acres, or why don't we just condition it as to 1 for 1 at the end of whatever's been cleared. So if we clear 5.5 acres, 5.5 acres, we clear 6, it's 6. I think that would be easier for us to understand. And then the second comment I would like to put on there is, we have 43 acres here. Once we go through and condition X and clean up the site, we think it'd be most appropriate to put that 5, 6, whatever 1 for 1 on site in situ within the new cleaned up site.
That seems reasonable. And it's connected. Do you think we need a time frame on that? I don't think.
Well,
do you understand?
Yeah, no, I understand. the time frame though, what's the reasonable time frame from the company's perspective?
I think with a reasonable time frame would be within 1 year of COD.
Yeah. Okay. Yeah, that's reasonable.
All right. So should we try to craft that?
Sure. I move that the company protect offsite. Or in this case, I guess it's on site for 4 acres within 1 year of the clearing to the acres for 1-to-1 to the acres that they've cleared within 1 year. Does that sound correct?
Does that mean we don't have condition MM? This is taking over condition MM?
So I haven't seen MM. So can we repeat what M is?
Yes, we can. So MM right now says, the siting board directs the company to identify no less than 1 acre of the wooded area of the project site to be preserved for the life of the project, and to submit an updated map of the project site indicating the selected area not less than 60 days before beginning construction.
Okay. Yep. So we don't need to amend MM. This is an additional, unless you're suggesting we amend MM to include that. Is that what you're saying?
Additional.
Yeah, this is additional.
So you're saying that they should identify an area. I guess what I'm confused about is that what they're proposing is that they're going to, whatever they clear, whatever amount they're clearing,
right,
they're going to do a 1 for 1.
It strikes me that
But
we
it can
can
be on the site.
Correct.
It strikes me that we can amend MM to be
to
1
include
for
this,
1
yeah.
and add some degree of certainty that it's going to happen within 1 year of COD.
We can do that.
Can I ask a question from the non-environmental person? Is it also important to have to preserve comparable forests? So we're not 5-year-old trees, but trying to preserve 25-year-old forests.
I think it would be challenging to do that, to find a site that has that type of condition, and it's an ephemeral condition. So I think the importance is that we're making sure that there is some assurance that what we've lost in forest is preserved somewhere else. So an amendment to MM, if that works, I think is reasonable. I know we already went through the amendments of previous conditions, but if that works, it's fine. You want me to make a new motion then?
Yes, please.
Okay, so I move to amend condition MM that the siting board directs the company to identify no less than 4 acres to identify on a 1-to-1 basis wooded areas of the project site to be preserved for the life of the project, and to submit an updated map of the project site indicating the selected areas not less than 60 days before beginning construction.
Don't we need to do the 1 year piece?
Well, that it be preserved within 1 year of. So indicating the selected area not less than 60 days before the beginning of construction, and then preserved. So indicating the selected area not less than 60 days before beginning construction, and then preserved within 1 year of the clearing or the COD. Commencement of
COD.
the COD.
But do you mean, you said 4, but you mean 1-to-1, not?
Well, that's, we corrected that on the fly. Yeah, that it would be 1-to-1 and not 4 acres.
I'm wondering if David might read that condition back to us, if that's possible.
Yeah, yeah. Restate.
I'll restate it again, the best.
Agreed.
Okay, let me restate it for the multiple time here, but I think we're going to get it right now. The siting board directs the company to identify no less, or to identify on a 1-to-1 basis, a wooded area of the project site to be preserved for the life of the project, and to submit an updated map of the project site indicating the selected area not less than 60 days before beginning construction, and preserved within 1 year of COD.
The only thing that might be useful to clarify is that it doesn't say what the 1-to-1 basis is. Like we want to basically compare it to the area of woods that are being cleared for the project.
What if we say the setting board directs the company to provide 1-to-1 mitigation for any and all tree clearing by identifying an equal wooded area of the project site? And then the rest as stated by Commissioner O'Shea.
That's fine.
Okay, vote on that.
A 1-to-1 basis by acreage as opposed to by tree.
I said an equal wooded area of the project site.
Forest of
Prefer
equivalent
equal wooded
value.
acreage. Would you prefer equal wooded? Oh. I had suggested identifying an equal wooded area of the project site. Is it more clear to suggest equal wooded acreage? Is that?
I think the way you said it is good.
Okay.
Now that you, just the fact that you referenced wooded area, good enough. Thank you.
Okay. The analyst team may have had some input to provide, it looked like.
So, yeah, with this, where this conversation is going, I mean, I think it's also good to examine, what's the point of the conservation? Because usually conservation easement go perpetual, not like 25 years. So I think that's also a consideration where it was very awkward if some forest is preserved for 25 years and then the best is decommissioned and then now someone can cut it. So it just made very awkward. So it might be worth thinking about that aspect. That wasn't, the intention is perpetuity. And it was not to, have a forest for 25 years. It was in perpetuity for protection. I think that might be something that company might have to consider because they may preserve some pieces here and there, but if it's perpetual, they might have to think more strategically.
Well, the condition, as stated, is to preserve it for the life of the project.
Which
so this is not a conservation easement. This is not in perpetuity. This is their
That's a good-
obligation is for
yeah.
the life of the project, you're mitigating 1-to-1.
Yes, so that's a good point. I think the intention was to have an acreage that is preserved in perpetuity through a conservation restriction or similar type acquisition.
Okay, so we're going to further amend that to replace for the life of the project for in perpetuity. And I would like to make a motion to adopt that condition.
Would you like me to attempt to read it back with that amendment so we all know what we're voting on? Okay. The siting board directs the company to provide 1-to-1 mitigation for any and all tree clearing by identifying an equal wooded area of the project site to be preserved in perpetuity and to submit an updated map indicating the selected area, parens S, 1 year after COD. Commissioner O'Shea is furrowing his brow. Does that do it?
Can you repeat the last part of it again around the COD?
To submit an updated map indicating the selected area, parens S, 1 year after COD. Did you want the map in advance?
I think we wanted the preservation within 1 year of COD.
Okay.
That the area be selected 60 days before beginning construction.
You want to keep the not less than 60 days.
For the selected area, correct. Want me to restate it now? Okay.
Good.
Thank you and appreciate your patience. The siting board, I make a motion that the siting board directs the company to identify on a 1-to-1 basis equal wooded area of the project site to be preserved in perpetuity and to submit an updated map of the project site indicating the selected area not less than 60 days before beginning construction and to preserve the wooded area within 1 year of COD.
Second.
Okay, let's vote.
Chair McDermott,
Yes.
Commissioner Mahoney,
Yes.
Commissioner Heupel,
Aye.
Commissioner O'Shea,
Aye.
Director Goodrow,
Yes.
Mr. Callahan,
Yes.
Mayor Cahill,
Yes.
Mr. Bonfilio,
Yes.
and Secretary Tepper.
Yes.
Motion is approved.
Okay, other amendments. Mr. Kuchar.
I just had a question, and it might already be embedded in there. We had discussion about, and we made modifications thanks to the staff to well water sampling radius before, after. Is there a provision or conditions that if there is an incident and contamination associated with the site, that bottled water would be provided for a period of time? Or is that necessary?
The condition RR, which is on the amendment sheet that addresses private well water supply, does include a provision that the company shall remediate water quality deficiency and provide an alternative source
Good.
of potable water until the water quality issue is resolved.
Thank you.
Any other amendments? Okay. Yes, you could still add if while we continue to talk. All right, so we're now going to think about voting on the entire tentative decision, inclusive of the amendments that we have already voted on. So who would like to begin the discussion on that?
Are we discussing before we put a motion on, or is the motion that we started this discussion with sufficient?
We have a motion on the table that is sufficient.
Okay, thanks. Guess I can
Go ahead.
start us off.
Ms. Mahoney.
And you know, first of all, thank you for everyone for staying over time. And thank you to everyone for really trying to get through this difficult consideration that we have before the board. In particular, I want to thank the town and the interveners for your thoughtful and meaningful contribution to what we're about to vote on. I especially want to call out Councilor Pucci and your opening remarks from earlier about that, the town remains opposed to this, but also knows its, ultimate responsibility to the town to work on this project if it moves forward. So I think that is, even given the difficult nature of the last couple of years, that's notable. So thank you. I think I'll just reflect on having listened to today and read the thoughtful comments that the community members have offered, and the record that is before us, that, I'll note, recognize that this is a difficult decision, and that we have to balance a lot in making this decision. We have to notably balance what the legal requirement and framework of the board is, and including some new statutory language that we are reflecting on and was addressed earlier about Public Service Corporation. And also, quite frankly, the emerging nature of these technologies and the responsibility that all of us in the Commonwealth are going to have to consider. So, we start with the legal framework, we start with the evidence, and then naturally we bring to the discussion here and our deliberation, everything that we know from our various backgrounds. You just heard a little bit of a discussion about, environmental considerations. That's different than my day-to-day work. I bring to the table, obviously, energy needs. So we can't divorce ourselves from our professional and personal experience when we're addressing these matters. But I think based on what we have before us, there is a strong balancing here that we are trying to hit. And I think that is what certainly is driving my consideration, balancing the legal framework that the board must consider, the energy needs, the environmental needs of the Commonwealth, and certainly the reliability needs that we have for our energy system. So that is what is, really going through my mind. And again, just wanted to thank the staff for their time, the interveners, the town, the company, and the board for getting to this place.
Thank you, Commissioner. Any other comments? Mr. Gucher.
So I mentioned this earlier. I sit on the board representing Secretary Paley in the Executive Office of Economic Development, but I've also served for 22 years as an elected official in my own community. And so I understand these issues in a real visceral and neighborhood way. And I am truly grateful for the testimony from all the folks that came out today and those that are on virtually and all those that have submitted comments. It's really an educational process to help us understand things in that way. So at the Executive Office of Economic Development, our interests are really in reducing electricity prices, fair siting opportunities for rural communities, fair and reasonable community benefits, and revenues to communities, and protecting rural communities' interests in facility siting. And so economic development is supportive of this project for the following reasons. Massachusetts has expensive energy prices. This project helps shave the peak in both winter and summer to reduce spikes in electricity due to gas constraints in the system. Energy storage is among the fastest, cheapest, easiest ways to do this in the short and medium term. And energy storage will collectively help bring down prices to consumers. In addition, the project is located on a former junkyard. It's a brownfield site, which we've talked about. And moving the forward project will aid in cleaning up the brownfield contamination. The project's also proximate to a transmission line. In addition, while the town is opposed to the project, will provide some 1 million in projected tax revenue to the town annually. And that said, we do, EOED has a rural communities ombudsman that many folks know. And our Director of Rural Affairs has clearly heard a lot of the concerns from residents of the town. And she has come back and been a staunch advocate on your behalf. She noted that many in the town of Oakham have been exceptional stewards of the water resources and echoed many of the comments that we've heard today. And she emphasized that we need to strive to include a number of potential conditions that will be fair to rural communities. We've talked about most of those today, but EOED has had the opportunity prior to this to talk to staff, and I discussed many today, but among the concerns that we raised earlier were the need for consideration of LSPs, 3 LSPs, and obviously Commissioner Heupel made an amendment that was more beneficial to the town. We talked about the decommission bond. We talked about the pre-construction survey required to maintain and improve roads. All of that was covered in the amendments. We raised the issue which we just debated about mitigating for lost acres of forest. The noise and monitoring protocol we discussed in great depth today, but we had flagged that earlier as an important issue. Debris removal to be clean, not just around the site, but the perimeter. We, of course, Commissioner Heupel and Secretary Tepper alluded to that, and the company agreed. Notification requirements, a provision to ensure that the town could access safety equipment as necessary, and safety training, and the protection of private water supplies, both before and after. So we've covered many of the issues that we had discussed and raised previously and negotiated today. And with those amendments, EOED is going to support this proposal.
Thank you for your comments. Other discussion, questions? Sure.
There's no way around it. This is a hard decision. And Mr. Pucci, you're right. There's a very human element to it. And the weight of the comments here today, the weight of the comments in the record are a factor in deciding what is in the public interest. And I think that the public interest has a lot of different pieces to balance. There's no satisfactory answer for everybody in this room. And yet we need to make a hard choice. I think that the conditions that have been put forth in the TD and further amended today have done a lot to provide additional security and protect against the impacts of this in a number of ways. But it is not, it's not going to be enough to assuage all fears all the time. However, I think that there is a very real need for energy infrastructure across the board, and that this project will serve the public interest and the Commonwealth. So for those reasons, I intend to vote yes.
Any other comments? Commissioner O'Shea?
Sure. I just want to echo that I understand the concerns of the commenters today, the town. I live in a community not far from Oakham, not quite as country and rural, but on the spectrum, definitely closer to Oakham. And I can understand those concerns. And as I reviewed the tentative decision, I tried to see, where were those concerns addressed? Can they be addressed in the future? Is there recourse? And it looked like a lot of the things in there are being addressed. And I think this is a kind of project that as things go on, we need to make sure that we continue to ensure that these things are being followed and that these concerns are being addressed. But it is a difficult, decision, I think, as you're hearing from board members. And I think we need to, continue to keep an eye on this type of project, because in communities like these, I know that that's a big change, and they're contributing to, I think, really the benefits more publicly in beyond their own residential areas. So, I think it is a very difficult decision, but I think there's also been a lot of due diligence to see that concerns have been addressed. So, just wanted to share that.
Do you want to say anything? You're good. Anyone online want to have any questions or comments?
No.
So I've been working in siting of energy infrastructure almost my entire career. And this is one of the hardest cases that I have seen in my career. We all have really struggled with this case. Spent a lot of time thinking about it, really trying to think about conditions that would address some of the concerns that the community has raised. We have tried our hardest to do that. We know that what we are doing is not going to be satisfactory to you. What you want us to do today is to say no outright to this project. And I think where I personally am coming out is that this is a balancing issue, and it's a hard balancing issue. And, it's talking about different priorities. And, you have the priority on one hand of the need for new clean energy infrastructure in this state. We do need more infrastructure in this state. And balancing that against the host community needs and concerns that they have with a large infrastructure project coming into a town that is quiet, that is rural, that is has a particular ambiance about it, is a difficult balancing. And we're not going to get to a place where all the priorities fit as nicely together as we would hope them to. Excuse me. So I do want to note that the town's participation, active participation in this case, has been very helpful in gathering the evidence that is necessary to make a decision like this. And, it is very difficult to make a decision on a case like this when there aren't other parties involved, because the evidence isn't as strong. So very much want to thank the team and the interveners for the time and effort that you have taken to make sure that we have a record that we can consider that is full. Also just want to thank the interveners for the time that you have put in. I mean, you all have regular lives, and the fact that you spent the time and energy that you have on this proceeding shows how important it is to you and your community. So wanted to just thank you for that, and thanks also to the staff. This has been a very robust proceeding. You received over 700 comments, 400 IR, information requests, 7 days of evidentiary hearings and full briefing schedule. And, that's your job in adjudicatory proceeding, is to gather the evidence, and you have done that in a way that has been thorough and much appreciated. So thank you very much. So I think that the conditions that we're placing on the project today that we have been talking about are critical. I think that they are necessary for mitigating the impacts as best we can on the community. And I appreciate the thought that's gone into all of them. I also want to note that for the future, I am a strong proponent of community benefit agreements. And I hope that the town and the developers will consider options for going forward along those lines. We issued some conditions. We are going to issue some conditions today. It's quite robust conditions, maybe the many conditions I've ever seen in a case. That being said, there's still conversations that could be had. And, we encourage the developers to continue that conversation with the community. All right, anybody else? All right. Let's have a vote.
Chair McDermott,
Yes.
Commissioner Mahoney,
Yes.
Commissioner Heipel,
Aye.
Commissioner O'Shea,
Aye.
Director Goodrow,
Yes.
Mr. Callahan,
Yes.
Mayor Cahill,
Yes.
Mr. Bonfiglio,
Yes.
Secretary Tepper.
Yes.
The motion is approved.
Thank you all. We will go off the record and appreciate everybody's attendance here today.